Lordship, with notice to other side.
To mention a matter. For restoration, we have filed the application. I mentioned it last day before petition. Lordship said to file an application. I mentioned the application which has been filed.
Hand over the slip. So, serve notice upon all the parties.
This I'll again serve. Grateful.
Friday week, next Friday will be the holiday.
Friday. I'm so grateful.
Application content.
19th. Yes.
Application content.
Contempt arising out of the order passed by.
By Justice Rohit Gopal. Justice Rohit Gopal.
What is the stage of contempt?
They have not complied with. It is appearing for the first time.
Whether the first time appearing?
They appeared before several benches, but no order to be passed.
Month list of March. Yes.
Send the notice, appointment of Asha Kurmi.
Appointment of Asha Kurmi for what? So hearing, motion.
Motion.
Of which year?
It was out of list.
Of which year?
19.
Writ petition of 2019.
Yes.
Under which subgroup of under group 5?
5.
Group 5. Whether it is a municipality, cooperative society, which group? Subgroup?
Selection committee of Nishiganj Gram Panchayat committee.
It's a panchayat matter?
Yes.
Have you served notice upon other side? Where is the notice? When you have served notice?
The Nishiganj committee for on Gram Panchayat.
When you have served notice upon the other side? Don't waste court's time.
Yes, 3. 3rd January.
Hand over the slip.
Lordship,
Combined monthly list March.
Lordship,
Under
may I
the
leave
heading
to,
panchayat hearing.
Lordship, may I leave to mention one matter?
Yes.
In this is a 2009 matter. But unfortunately, this is a transfer with
The hearing matter or contempt?
motion. No order passed. Matter
Under which group?
under Group 5, Lordship.
Group 5 motion of 2009.
2009.
March
there is-
2009, March monthly serve notice.
And there is
Are you serving with a,
Lordship.
are you mentioning
Lordship,
notice?
with notice, Lordship.
Yes.
And there is another matter, Lordship. These the unfortunately petitioner not getting, in spite of several order of this honorable court, he is not getting the pensioning benefit only because of by grudge.
Which group?
Group 5, Panchayat
Which
matter,
year?
job exchange. 2012 and 2020. There is analogous matter, Lordship. One is for dismissal.
Affidavits are complete.
Affidavits. No affidavits filed. No affidavits.
Direction for affidavit was there.
In the first matter, there was a direction for affidavit, but no affidavit filed. Later, for pensioning benefit, I have filed the motion,
Monthly list of March.
Lordship.
May I be permitted to mention this contempt application order passed by my Lord Justice Lopita Banerjee, and I have filed this once it has been come.
What is the stage of contempt?
The notice, sir. Direction was passed.
March monthly list.
Can it be February?
Serve notice upon say no, sorry.
May I have a kind,
No, sorry.
may I have a kind leave to mention a contempt item for inclusion, my lord. The order was passed by my Lord Justice Pratik Prakash Banerjee, as his lordship then was, in the year 2019, my lord.
What is the stage?
My lord, one notice has been served.
March monthly list.
My lord.
Lordship. Serve notice upon other
Yes, my
side.
lord, I'm already serving it on notice.
To mention, my lord, it is the matter of 2020. Under Group 9. But the petitioner is being prejudiced by the appointment of the private respondent in the Muslim marriage register. And wrong.
March monthly list. Are you serving with notice?
I have applied to serve. But
When?
When?
When you have served notice?
when I'm not served, but I have
No, without notice, sorry.
panel.
Sorry, without notice, this court does not entertain mentioning. Yes.
This is the 219 matter, my lord. Your lordship directed us to file the affidavit in reply that has already been
Which
complied.
group?
Group 5 Panchayat, my lord. My lord, I will
Group 5 Panchayat.
Panchayat, my lord.
What was the last direction?
My last direction was to file affidavit in reply. We have already filed, my lord. The age of super.
Are you mentioning with notice?
No, my lord. I will.
Sorry.
Lordship.
Serve notice and come back. Yes.
I am mentioning to contempt application. One order passed by Justice and another matter was passed by Justice Devashish Kaur. Appeal was pending. That appeal court has confirmed the order of the single bench.
In both the matters.
Both the matters.
Monthly list of March serve notice upon other side.
Lordship, may I mention?
In the
Yes.
Long pending matter, the notification is stopped, they are appeared several times because it is up to the Bharat.
How many matters are there? 3 matters. Regularization. Then
All these are very.
April, monthly list of April. Yes, yes. Next. Sorry. Yes.
For inclusion, Your Lordship, it was passed, the order was passed by Justice Pradeep.
Inclusion under which group?
Contempt application.
Contempt application. What is the stage of contempt?
Your Lordship, we solved the other side, thereafter it was pending in Justice Bharadwaj's court and
Served.
yes,
Then what happened?
they had come and the other side came and said that an appeal was pending, Your Lordship. The appeal has now been dismissed.
When appeal was dismissed?
2022, I believe.
Then after that, why you have not taken steps?
Your Lordship, because it has been pending.
Pending, that's why you are mentioning. Disposed of, you could not have mentioned this matter.
In the list, Your Lordship, but it was not taken up. It was taken up in the month of October.
Very well, April month list. Yes.
My lord, I am mentioning one restoration application. My lord, it was dismissed by Honorable Justice Dipankar Datta in 2016, my lord.
And when you have filed the application?
My lord, it was filed then, within time, my lord.
Then why this matter was pending for such?
My lord, the learned lawyer is untraceable. I am the changeover brief.
Monthly list of April.
Application for
notice.
application for restoration.
When it was dismissed for default?
2019.
19. So what you are doing for such a long time? When you have filed a restoration application? When you have filed restoration application?
Advocate on record.
When you have filed restoration application?
2022.
22. Along with section 5 or without
Yes,
section
yes,
5?
yes.
Monthly list of April. Serve notice.
Lordship, in the month of December, middle of the month of December, I mentioned the contempt application. Lordship direct me that would be listed January monthly. Despite direction, I have
Under which heading?
I already have the
Under which head? Matter under which head?
Lordship, that is the unauthorized construction which has been heard before the Honorable Justice Arundam Sinha, and thereafter affidavit served, rule issued.
So you want hearing of the writ petition?
Lordship,
Of which year?
Lordship, that is 22 million. Rule has been issued.
22 writ petition you want hearing. Affidavits are complete.
Rule has been issued in the contempt.
Contempt, say so.
When I mentioned the matter, Lordship instruct me that would be listed in the January monthly list. Accordingly, direct me to serve the copy. This is the notice also given as per Lordship direction. In spite of Lordship direction, that has been listed in the January monthly. That's why I have come before Lordship today.
This week, this month, there will be a difficulty because only 19th is the day when contempt matters will be taken up.
In any
Because 2012 will be the holiday, 26th will be the holiday. Only 3 Fridays are left, out of which 2 are holidays.
Lordship, we need in any day will
Combined monthly list of February. Yes. দিয়ে দেবেন এটা একবার allow করা হয়েছিল. Yes.
Application for restoration.
When it was dismissed for default?
Miller, it was on 5th of 5 of 2023. So like it was once 243 was my matter and 183 was
When it was dismissed for default?
on 18/5/2023
Very well. By this court?
by this court.
Very well. Sub notice next Friday.
My lord, may I permitted to mention one contempt application?
Next Friday week. Yes.
Contempt matter. It was passed by the Chief Justice, then was and
Yes, you do you want to mention any matter? Yes.
Yes, my lord, in the last occasion, my lord, in the monthly list of December, item number 133 is in the list, but that the next hearing date was stated is telling that in the January monthly list that will be come, but that is not in the list, my lord.
It was appearing under which head?
Group 5.
Group 5, which head?
Motion. Unauthorized construction under motion.
Your panchayat matter or municipality?
Municipality.
Are you mentioning with notice to other side? No. Municipality motion of which year?
2019.
Well, come, let it be in the monthly list of February.
Yes.
Lordship, may I have your kind leave to mention two writ petitions pertaining to my lord Panchayat for non-prosecution.
Non-prosecution. Serve notice upon other side, come back.
Lordship. Lordship, may I hand over the slips?
11th January.
Grateful.
My lord, may I permit to mention one content matter. It was passed by Honorable Chief Justice, then was, and the matter was taken up by Justice Bharatdaj as well, and the matter was appeared before.
Chief Justice passed an order, thereafter contempt was taken up by Justice.
Yes, taken up.
With Justice Bharatdaj, how that is possible?
Was by
Because the Chief Justice was the Honorable then Chief Justice passed this order sitting in the division bench.
yes,
How Justice Bharatdaj has taken up this matter?
it was by
Ascertain and then mention. Yes.
Lordship, may I permit it to mention the expression application
When it was dismissed for default? No further mentioning today. Yes.
August Lordship, 2023.
2023 restoration. Dismissed by whom? By which court? Ascertain and then mention, call the list. Sorry, no further mentioning. No further mentioning today. This court allows mentioning every day.
I appear for the petition, Lordship.
Demarcated.
Yes, demarcated, but shall filing my affidavit in opposition.
Well, I'll file the report, my lord.
To the two application for addition of parties.
Application for additional parties by whom?
By two clerks.
Oh, that the last occasion these applications were filed.
This application is filed.
Just a minute.
I go with back to me. Go back to thank you. I should have started, yes. Position. দেখো না পুলিশগুলো যখন এই মামলা ঠিক করে কাটে চলে ঠিক বলে তুলছি বন্ধ হয়ে গেলে কালকে কোনো খেয়াল করো তো মামলা নেই কোন করেছি
The prayer iftar bade. Page 40.
আপনারা করোনা কি অর্ডার তো দেখায় না এভাবে হয় না
Who is for the respondent number 12?
No one is appearing today.
Lordship, I am appearing online for the applicants in CAN 2 and 3.
I have asked for appearance of respondent number 12.
Addition of party.
Yes, what do you want to submit? Whether the copy has been served upon you?
Yes, Your Lordship.
The report enclosing the measurement, demarcation?
Yes, Your Lordship.
I've given it, my lord.
Yes, the map.
Yes.
And
Now,
the learned advocate,
demonstrate
he
your
was
case.
present and his
Yes, yes,
letter
I
is
was
also-
present. I was present on
Letter has
spot.
been also
Now
annexed to it.
demarcation has
Demarcation has been done.
Yes, Your Lordship.
Done. Now, yes, place your case. What is your grievance?
Yes.
Let me see.
Now, I invite your Lordship to the prayer of the writ petition.
This writ petition.
Yes, Your Lordship. This is
But where is this
23892 of 2019.
Well, I don't think anything remains in this writ petition any further because the only point out here was demarcation. If they want
No.
possession, that's beyond the scope.
How can they?
If they want possession, now they want possession, Malad. That they'll have to go and file a civil suit.
No, no. How can that be?
You get
I
something
can satisfy your Lordship here and now.
Very. Both of you are representing state.
Yes, I presume so.
My lord, my government Peter has engaged me subsequently along with him.
That is in between you and Mr. Bose. I am not going to determine.
A GP is also there in this matter.
Petitioner additional party করেছিলেন
China. Additional party. Right, as a shine.
হ্যাঁ তাহলে my learned friend is appearing for the applicants who has filed this application for additional party two clubs, Obhijan Club and Azad Girl Friends
That
Club.
will be considered.
Yes.
I have filed my
Let me hear the
opposition.
writ petition. Otherwise, these clubs will come and go on making applications. I will consider.
I have filed my opposition with Lordship and I can sum them up.
Just a minute.
You give me a copy if you have it.
It is the application of party.
হ্যাঁ তো তাতে আমাকে কপি দেবে না অ্যাপ্লিকেশন ফেডারেশন কোথায় থাকো
আপনি petitionটা সার্ভ করেছেন?
So, chiefly, you have filed this writ petition for enforcement of the orders.
Yes.
Passed in other writ petition. That is permissible. Then,
Now, the Lordship will kindly see the prayer portion.
prayer B.
Yes, sir.
E6.
Lordship will kindly come to page 38. The
Yes,
prayer
prayer B.
start from page 38. Now, prayer B. Leave be granted to file the present writ petition praying for enforcement of orders passed by this honorable court dated 20th April 2008 and 18th April 2001, 2011 passed in WP number such and such.
Now come to page 39. Come to page 39. Prayer D.
Lordship.
To act upon the order of this honorable court dated 28 April 2008 in WP number so and so, being annexed P6 herein by demarcating the vested and unvested portions of the premises of 130, and that has been done.
Yes, but demarcation, Lordship, demarcation does not mean that only two lines will be drawn and a portion of the boundary wall, there will be just a sketch. Demarcation means actual physical demarcation, whether that has been done or not.
Court has to consider the matter in the contours of the prayer couched in the writ petition.
Lordship.
Now, you have made it, the two relevant prayers are prayer B and prayer D. Now, prayer B is about demarcation that has been done. Prayer B is implementation of the order dated 28 April 2008, 18th April 2008, 11 in the writ petition number so and so.
Your Lordship also consider prior
that you have made out a case for possession.
Your Lordship will also consider prior F, page 40. Why I'm saying so, Your Lordship, there's a reason. Prior F, Your Lordship will kindly consider issue a writ in the nature of mandamus commanding the respondent such and such to ensure that peaceful possession of the petition
That's
of the
why,
unvested portion.
Mr. Majumdar, you have to chronologically place the facts in order to consider the issue.
Yes, Your Lordship, I can.
Yes, yes.
Yes.
Well, in a nutshell, can I cite to Your Lordship this decision of Honorable Justice Dipankar Datta, on which my learned friend, junior friend, has relied upon? Here it says that they are not in actual physical. This is at page 72. This is explicitly clear. Kindly comes to the third paragraph, page 72, the third paragraph. It is further submitted by Mrs. Roy that the land in question is a vacant land and the petition is not in actual physical possession thereof. The second part of the submission is disputed by Mr. Banerjee, learned counsel for the petitioner. The police authority shall ensure that nature, character, and possession of the land is not changed by any of the parties dispute during pendency of the writ petition. Let affidavit in opposition be done and so and so. And this writ petition has not been disposed of.
So this writ petition is pending.
Yes. So, so far as this writ petition,
the order in the second writ petition, Justice Indira Banerjee, as a ladyship, then was passed an order determining the right of the petitioner.
Yes,
no, Justice
And there
Indira
is no
Banerjee's
harm
order.
in deciding both the writ petitions. This one and the writ petition being WPA 6765 of 2008, so that the matter can be so that a quietus can be brought in.
yes, yes.
Yes. So,
But my lord,
what
only
is the
one thing,
difficulty in deciding the possession of the petitioners?
only
Since the
one thing.
petitioner has prayed for Mr. Basu,
Prior F, Your Lordship.
39. Page 39. F is to ensure that peaceful possession of the petitioner of the unvested portion of the said property being so and so is not disturbed and not disrupted.
and also prayer issue a writ in the nature of mandamus, prayer DE, annexure P9 herein by removing the illegal and unauthorized constructions.
I presume in this particular part there is no
Unauthorized
unauthorized construction as of now, because there were only temporary structures. So unauthorized construction does not, it moves off.
Yes, yes. Demonstrate your right.
Now, Your Lordship, this writ petition was filed first for implementation of two orders.
No. First, from the demarcation which has been made,
Yes.
so that which part is yours, which part has been unauthorizedly occupied by the stall holders or other persons.
Now, Your Lordship has been handed over with this report.
Yes.
Now, there is another report, Your Lordship, which was filed by Urban Land Selling Authority. That will be a report.
First, demonstrate from this report. Let
Yes.
me see.
Now, Your Lordship, you kindly see this map.
Yes.
Now, this is the main road. This is the wasted portion, and this is the retained portion.
Which one is the wasted portion?
This
KMC road, the portion which is admeasuring 21,140 by 21,920. Is it a vested portion?
No, no, no. There's a center line that says 32,700.
It's a diagonal line.
Yes, 32,700.
This is the retained portion. This is the unvested portion.
This is
Now-
your portion according to you.
Your Lordship.
And what about the portion of the premises of 138 NS Bose Road that is behind
That is
32,700?
originally the land was 22 katas. Now, out of that, 15 kata was wasted. It was wasted with Kolkata police to build a quarter.
That portion is behind this
Yes,
32,700.
this is that portion. This is that portion. Now, all of this portion is being occupied by the club.
All of this?
The entire land is being occupied
Including
by
the vested land?
Yes, Your Lordship. Till date, Kolkata police has failed to get possession of the land. Till date, Kolkata police, when was this vested portion, when was, Your Lordship will kindly take this report, which was filed in court by Urban Land Selling Authority. On 28th February 2023.
So
Lordship will
therefore,
find
this 21,140 by 21,920, it is in, what is the measure, Mr. Basu?
This is 7.5 kata.
Or
7.5 katas.
this front portion?
This is this is one portion, may I say.
Now 15 kata,
Unvested, which is not being vested.
which is their portion of the land.
7.5
5
kata.
katas.
And the remaining 15 kata has been vested with the Kolkata police for building quarters. But till date,
that is 22 minus 15.
Yes.
Yes.
But till date, Kolkata police has not been able to take
That's
possession
their
of the
headache.
land.
That's the headache.
So why he will not get back his land after vesting?
His land was never taken away by anybody. His land was always there. He purchased a plot of 22 katas.
Yes.
Vested portion was 15. This retained portion is 7.5.
Whether the petitioner purchased after vesting?
Yes.
No, no, before vesting. Before vesting.
Before vesting.
I can show you, Lordship, the deed. I can show you, Lordship. I purchased 22 kata of land.
Vesting was in 1976.
And
No,
when
no,
petitioner
1996.
When petitioner purchased?
Petitioner purchased the land in, Your Lordship will kindly see the deed petition. I have the deed, I have attached the deed.
Oh, vesting was in 1996.
Yes.
So therefore, Mr. Bose, after vesting in 1996, the portion which was not vested,
Yes.
that is 7 kota, why petitioner will not be permitted to have the possession over this 7 kota?
Malad, we had never taken possession of the same. This vesting was just a paper vesting, if I may say so, because all the records are not also available.
I am not concerned with vesting because before this court, vesting is not under challenge.
Yes.
Petitioner wants that the portion which is not vested, which didn't was not vested, that portion to be retained by the petitioner. Petitioner wants to retain that portion.
Let him retain it.
But the problem is that there is.
We have taken.
Malad, 15 katas of land was taken possession of. 7.5 katas was left as it is.
7.5.
Yes, their portion.
Not 7 kata.
7.5, I said, Malad.
7.5 is the unvested
There's
portion.
nothing to it. We have not even taken it in possession. So why this? I have got nothing, no stake.
Allegation of the petitioner is that he is not in a position to enjoy the possession of that 7.5 kota.
Malad, he had purchased
due to club.
Malad,
The club is the problem, Your Lordship.
That will be a private. That will be a private.
The state is not the problem.
If
The
it
club is the problem.
If it's the private club and Malad petitioner, it's a private dispute. Malad.
No, I can show you, Lordship.
The writ petition is
I can
not
show you,
maintainable
Lordship.
anymore.
The report filed by the state.
We had
I can
done
show you,
what
Lordship,
had to be done because there was no demarcation.
So 22 out of 22 quotas, 15 has taken by the government by way of vesting, and 7.5 will be has been taken by the club.
Yeah.
And petitioner will be left with empty hand.
Only us. That's a retained land. Club makes certain structures, temporary
What
structures.
is the right of the club?
No rights.
No right.
No rights. We're not saying that we do anything. The government does nothing about it. The vesting people, we UID have done nothing about it. We have left it to him. If he cannot guard his own land, that's not our problem.
The state has to ensure that
Septuagenarian lady She will guard his own property in
My lord,
this fashion. Is it a welfare state or not?
My lord, it's
Mr.
a
Bose,
welfare state. It's
what
a
was
welfare state.
submitting?
But at the same time, your lord,
By sheer use of muscle power, like, land will be grabbed that too in the area which comes under the jurisdiction of Kolkata Municipal Corporation.
I
And now you are
understand.
terming this dispute as a private dispute.
But if the club takes away the my lord, just kindly bear with me for a moment. If the club takes possession on and off, and there is no order of the Honorable High Court at Calcutta, my lord, suo motu can we assume jurisdiction?
No, there is an order passed by Justice Banerjee. Let me take to
Your
the
Lordship,
order.
Your Lordship,
Yes,
for a moment,
passed
just
by
for a
Justice
moment.
Banerjee.
Kindly
Just a
take
minute.
an order passed on 14th March 2023 by Justice Sinha. 14th March 2023 order passed by Justice Sinha.
There's an order passed by Justice Banerjee, Justice Indira Banerjee. Just a minute.
Justice Indira Banerjee's order, Your Lordship, will find at page 88.
Page 92.
Page 92. It starts from page 92, Your Lordship.
Come to page 90.
Yes, 92.
94.
90.
Relevant part
Yes.
of that order.
Is after hearing Mr. Shuknath Mukherjee's learned senior advocate appearing on behalf of the petitioner and Mr.
The
Gostam.
petition is disposed of by directing. Read it, Mr. Bose.
Yes. The writ application is disposed of by directing the municipal corporation to take immediate steps for removal of the unauthorized constructions on the pavement forthwith, and in any case within 60 days, working days,
Nothing has
from the
been done.
date of communication of this order. The respondent number 5 shall render necessary assistance for removal of the unauthorized constructions. As for the KMC, if they tell us, we will assist. But if the KMC doesn't tell us, we cannot assist. Madam.
Yes, that's true.
KMC
That's
is being represented.
yes, Mr. Ghosh. When you are going to remove this unauthorized construction from the pavement,
Well, I have to take instructions. I do not know, my lord, regarding the another.
you are appearing regularly. Your name is appearing on the
My
in the
name is
orders.
not regularly appeared. Not regularly.
Regularly.
Not.
Yes.
He has been appearing in the matter since 2019.
But the initial dispute was with regard to the vesting part.
No. Regarding vesting, there is no dispute at all.
No, now
Because vesting part,
now
petitioner has not thrown any challenge to that vesting.
Now it appears well the vesting part and the non-vesting part has been made separated.
No, there is an order passed by Justice Indira Banerjee directing Kolkata Municipal Corporation to remove unauthorized construction from the pavements. What steps you have taken? Petitioner has come up with the writ petition for implementation of the order dated 18th April 2011. Club has taken the land. Major part of the land has been taken over
Not
by
only the major part, the entire part.
entire part. And
When
whatever
Kolkata
this pavement
that is being occupied by illegal shops. Till date, Kolkata police has not been able to take position. How can Kolkata police say that a writ petition, 80-year-old lady can take position when Kolkata police could not have taken position?
Kolkata police will take position.
Let them take position first.
It is now.
Let them take position.
Kolkata police will take position.
The land is under the possession of the club, actually.
See, there were 3 orders passed by your lordship, and then demarcation could be done.
Cannot take possession.
No, they have taken possession. It's a symbolic position.
Yes.
Nothing else.
And club is occupying it.
Has not taken position, only the local teenagers they play.
Well, I'll direct to remove the encroachment, and also if club is there, they shall be removed by the
Yes, your lordship.
Kolkata Municipal Corporation as well as the police authorities.
Can be done.
I think government will also using the vested land of the state.
Yes, your
The
lordship.
police authorities. And the police is doing nothing. So we cannot have it.
Mr. Ghosh, take instruction, come back.
The pavement.
On the pavement. And this court will direct for removal of the unauthorized occupation as made by the local club. Respondent number 12. And hand over the possession to the petitioner. Vacant possession of land.
Position, who will give the position? My duty is to
vacate the land.
I will take
They will have
position.
to take possession.
Vacate the land.
I will take position with the assistance of
Petitioner
Kolkata
will
police.
take possession.
demolition of the structure.
Yes.
Whatever the procedures provided under the act, that will be taken, or you will.
No, already court has passed an order. There is no question of any
That is
procedure.
that is with the pavement.
Yes.
That is with regard to the pavement. Pavement is one aspect, and if any also.
What is the position with regard to the land? Is there any permanent construction made by the club?
Yes, Your Lordship.
Permanent construction?
Over the 15 kata.
Over the 15 kata?
Not on my land.
What construction they have made?
They have made a club
over
room.
the 15 kata, they have made construction.
Yes, Your Lordship.
On 15 kata, there's a construction, but this is absolutely empty. This is empty.
Over 15 quota, there is a construction by the club.
Yes.
Lordship, how can they
regarding
do that?
7.5 quota, there is no such construction.
That is vacant. That is vacant. How can club construct over a land which has been acquired by Kolkata police? Then how can Kolkata police say?
None of the petitioners.
This is not your concern.
That's not my concern.
If they want to enjoy the local club,
Let them.
enjoy
I just
15
want.
quota, let them.
I just want
land
the assistance of Kolkata police.
But so far 7.5 quota of the petitioner
That is
and
vacant.
the adjacent unauthorized occupation as made by the local persons by erecting stalls. These are to be removed by the corporation.
No, as per the 7.5 kata land, that land is vacant. That land is vacant. I can assure Your Lordship, that land is vacant. But on the from the main road, there is a pavement. That pavement is being occupied by illegal shops, not on the land.
So therefore, there is a problem with regard to ingress and egress.
Yes.
Only one thing.
Ingress, the problem related to ingress and egress is being caused by the club. I cannot go there and build a boundary wall. This is my land. Even this court on 14th March 2023 has categorically passed on. You will also kindly see the order dated 14th March 2023.
What has been stated?
The sketch map clearly mentions that the club is occupying a portion of the wasted land. The same implies that the club does not have any right over the retained land of the petitioner. This is an order passed by this court. The club, not the state, have challenged this order. So this order has reached finality. So this honorable court has come to the conclusion that the club does not have any right over the retained portion. Now this retained portion, if I have to enjoy the retained portion, I have to build a boundary wall. Now they will not allow me. It took 3 orders from your lordship just to demarcate. That was symbolic demarcation, not a physical demarcation. They just went there, just drew some lines and all. That was that. Now, in order to enjoy the land, I have to build a boundary wall.
The petitioner is concerned is the unauthorized occupation of the pavement by the stallholders.
Yes.
Not only unauthorized occupation, I need a direction from your lordship and an assistance from the Kolkata police that I will raise a boundary wall. They will assist me. I will raise it at my cost, no doubt. I will raise it at my cost, but they will protect me. Because the moment I go there to raise a boundary wall, there will 200, 300 people, they will come and say, we will not allow you. When this honorable court has come to a conclusion that club does not have any right.
Mr. Lairi, you are representing the club, respondent number 12. Respondent number 12. Yes. I am hearing this matter for last at least 25 minutes. And now I have gone through the demarcation report. Now the thing is this, it appears that there is a land of 22 quotas, total land. Out of this total land of 22 quotas, 15 quota has been 15 quota vested with the state government. State government and the rest of the land, that is 7.5 quota according to the petitioner and the state government, is owned by the petitioner. Now 7.5 quota petitioner is saying, state is saying that this 7.5 quota, there is a vacant land. There is no construction made by any club or any authority. But in 15 quota land, which vests with the state government, there is a construction by the local club. So we are not, this court is not concerned with the construction made by the local club to the extent on the land measuring 15 quota, which vests with the state government. But so far the petitioner is concerned, 7.5 quota is a vacant land. And adjacent to this land, the road, which is KMC road, on the pavement, there are certain stalls. And these stalls are creating problem. And already Justice Indira Banerjee passed an order directing the Kolkata Municipal Corporation to remove the stalls. So if the stalls are removed and petitioner is given possession of this 57 kata, not 15 kata, 7 kata, 7.5 kata, matter ends.
With regard to removal of stalls, we cannot say anything.
Because already order is there. Yes.
We are not the persons who are occupying the pavements. We are in a different. Second point with regard to the retained land that Lord Friend is saying, he has to go and convince the authority with regard to his retention as to whether he has filed the appropriate forms for retention or not. His representation is pending.
Who has filed a form or not?
He has to
What
go
form?
before the urban land ceiling authority.
This is not the case of the urban land ceiling authority. That due to failure of forms for submission of forms, that is an issue in between the petitioner. That is an issue in between the petitioner and the urban land ceiling authority.
Yes.
Urban land ceiling authority is not questioning the right of the petitioner over 7.5 quota of land. So therefore today you are not in a position to take this point. The club is not in a position why the prescribed pro forma has been submitted for or not for retention of the land of 7.5 quota. That does not that submission you are not in a position to make. Only thing is this, that the urban land ceiling is saying. On the contrary, urban land ceiling is saying that 15 quota plus 7.5 quota. 15 quota vests with the state. How this land is being used by the state, this court is not concerned, because that is not the issue before this court. So far 7.5 quota land is concerned, that is the ownership lies with the petitioner, but petitioner is not in a position to enjoy the ownership of the land and utilize the land in view of erection of stalls, not by club, by certain other persons, which impedes ingress and egress of the petitioner. Already that issue on the pavements. Already that issue has been decided by this court. Already this issue has already been decided by this court. Video order dated 18th April 2011 was for removal of these stalls. So now this issue need not be re-agitated before this court or reconsidered by this court. So let there be, I shall direct the Kolkata Municipal Corporation with the assistance of the local police authorities to remove those stalls. Yes, and allow the petition, and I will direct the authorities to allow the petitioner to enjoy the land in question, which comes in favor of the petitioner after vesting.
Now, my lord, my humble submission to that effect is that the prayers in the writ petition, there is nothing indicated with regard to raising of a boundary.
That's not there. That's not there. I checked.
Yes, the prayer
of raising of a boundary. There is no readings to that effect.
No, I will not direct to raise boundary wall.
Exactly.
If I am an owner of a particular land at measuring 7.5 quota, how I will utilize, how I will, whether I will raise boundary wall or not, that is completely my issue.
Yes, that's not in the prayer, my lord.
That is not in the prayer. You are absolutely
That's not the
correct.
issue.
And it comes to prayers.
So, if it is the land of the petitioner, how petitioner will utilize it, Mr. Lahiri?
Yes,
It is completely the thing or the issue which is to be decided by the petitioner. But today, what is necessary is this, that this encroachment by the erection of stalls are required to be removed.
There is already an order.
Very well. To that extent, you have no issue, Mr. Ghosh.
Let us, my lord, Joshua has heard the matter, my lord, extensive. There is, my lord, kindly comes to page, my lord,
Page 38.
Yes.
Prayer F and G, your lordship will satisfy your lordship. Prayer F and G, page 40 and page 41.
Just in.
Page 40.
Yes, page 30 is a prayer portion, is.
No.
Prayer F and G, your lordship.
Unvested portion of land take enjoy.
Peaceful possession of the petition.
Yes, what do you want to submit?
First is, my lord, leave, my lord, with regard to enforcement of these orders. No one can stand in the way. These are orders which has attended.
Justice Banerjee's order.
Justice Banerjee's order. Subsequently, there is an order of the Honorable Justice District Officer. Lordship was pleased to direct the urban land ceiling authorities to consider his representation. This representation is at page 82, which is pending, which has to be considered. Anyone cannot stand. If there is an order to that effect, my lord, there has to be a reasoned order with regard to consideration of this his representation. Next is with regard to, my lord,
I don't think, considering the stand taken by the state government relating to the right of the petitioner over the land to the extent of 7.5 quota, no further consideration is necessary.
That order is.
Because state is very candid before this court. So, with regard to the ownership of the petitioner is concerned about 7.5 crore.
That's retained
So
land.
what consideration will be
Yes.
made by the state?
I'm going on the basis of betrayal. I'm not the state, my lord. I do not know what is the stand of the state before the honorable court.
They have made a specific submission. Mr. Bose has made a submission that 15 quota land vests, 7.5 quota is retained by the petitioner. Petitioner is free to enjoy this land. Now the petitioner is before this court praying for removal of obstructions and so that petitioner can enjoy the land.
I am not saying no one can stand. Pavement, there is an order. Now with regard to the prayer 8 that Lord Friend is pressing, my lord, peaceful possession, this, my lord, cannot be done in a writ.
That has to rest in peace.
But this cannot be done in a
In eternity.
Rest in peace is eternal, my lord.
But if it is,
Till he rises for the judgment day.
Yes.
this cannot be done. I would have been the happiest person if these prayers were allowed by the writ petition. Then I would.
No, what right you have got to make this submission being a local club? I am the owner of a land of 7 quota after vesting 7.5 quota, and you will make statement that petitioner is not a private, it's not a dispute which is to be considered by the writ court.
Can you not see me as a club? Can you see me as an officer of the court assessing a writ court saying?
No, I can. So far, this matter is concerned, Mr. Lahiri, I cannot ignore the fact that you are representing a club who has no right over the land in question and unnecessarily hindered the proceedings of this court for last 5 months
No, my lord,
only for demarcation.
last occasion,
4 orders has to be passed by your lordship.
my lord, that I have been able to, my lord, things which were not being done in the last
So
5
therefore, conduct of the club, I am not personally against you, but the conduct of the club, while considering this writ petition, this court cannot forget.
We have to perspire, my lord. We have to perspire.
I had to pass. Yes, I had to pass 4-5 orders, and the Commissioner of Police, South Suburban, as well as Deputy Commissioner for South Suburban, then the urban land selling authorities, officer of the urban land selling authorities were present repeatedly, and ultimately it has been demarcated.
Yes.
Now, how I can forget this, and that too on the plea of a club? What authority this club has got? I will impose heavy cost upon this club, Mr. Lahiri. I am telling you, be prepared for that exemplary cost to be imposed upon this club. More you will open your mouth.
Why I say so? Kindly do not also forget they were on the misconceived notion that they will be disposed.
And it's a welfare state. This is my land. Out of 22.5 quota, 15 quota has been vested with the state government. Rest of the 7.5 quota lies with me, and I am not in a position for last 30 years to enjoy the land because of the interference made by the club.
There was no interference.
There is.
Very well, state
There
by
is.
state,
If
Mr.
we-
Ghosh. Mr. Ghosh. Yes, I will hear you. Mr. Ghosh.
Well, I'm saying only one of the regarding that order is there. It is to be removed, stalled from the pavement. They were one of the let my landowner give the full picture and the sketch map.
I will direct the corporation to remove this.
No matter where it is, that is
No,
the
no.
assets.
Whenever
Yeah.
any demolition comes upon the shoulder of the corporation, this is the usual stand of the corporation.
No, I'm just-
At least for 1.5 hours, I am taking the 1.5 years. I am taking these matters. I understand the position.
The existing position of the location of
Tell me when you are going to remove this toll
Your Lordship,
in terms of this order.
Kindly give me 3 weeks time. I'm just submitting to your Lordship, my lord. that
3 weeks
you-
for making an assessment when you will be able
Not
to
for
remove.
assessment, but I'm submitting my landowner will supply the
How
particulars.
can I supply the particulars?
Where the stalls
What
are
for?
there.
You will implement this order.
Pavement of the stalls
Come to page 94 of
on
the
the pavement of
come to page 94 of the writ petition.
the stalls on the
Mr.
pavement.
Ghosh, come to page 94 of the writ petition.
Stalls on the pavement.
Yes.
The stalls
Page
on the
94.
pavement. And I'm still looking at.
Page 94, after hearing so then this writ application is disposed of by directing the municipality to take immediate steps for removal of the unauthorized construction on the pavement forthwith, and in any case within 60 days from the date.
That is, I'm meaning that on the pavement, what the particular the stalls are there on the pavement. That's
Have you made for have you made a prayer for implementation of this order?
Yes, Your Lordship.
But this is not the repetition of 2010.
18th April 2011.
Lordship will kindly see the prayer. Prayer B.
Yes, 18th April.
18th April 2011.
Sure.
But this is the order of 2000.
How I am giving you 7 days time to obtain instruction and come back and to indicate when you will be, within which time you will be able to do this.
And Kolkata police also needs to give assistance, Your Lordship.
That is
Otherwise,
only when they require, Bala. When they require.
They are trying to give assistance.
they are.
That will
They
not
have.
be. That will be.
I would.
First club and now corporation.
I will submit Kolkata police. I am grateful
on the timelines every time.
There.
Lordship, I am grateful to Kolkata police for rendering necessary
The
assistance.
petition is taken up for consideration pursuant to the order dated 11 December 2023.
130 NH.
When Mr. Vivek Basu, Learned Counsel representing
The state UIDN.
competent authority, urban land selling, Kolkata,
our report
has filed
said that 7.5
a demarcation report signed on 22nd December 2027, which is taken on book. Next slide. It has been submitted by the learned advocate representing the petitioner. That out of total area of land in question, situates at 130 capital A, Netaji Subhash Chandra Bose Road, Kolkata 7,40,000. 15 quota has already been taken over by the state government by way of vesting, and 7.5 quota exact measurement.
Yes.
Then how 22? It should be 22.5.
22.5.
22.5 crore. 15 টা না আগে যেটা 22 লিখলাম সেটা 22.5 দেখো আউট অফ 22.4 ঠিক উল্টো করবে না হলে দেখো ওটা
অর্ডার দেখাও না
আচ্ছা না 15 taken over by the state government by way of 22.5 not 15 হবে and rest part that measuring 7.5 quota is owned by the petitioner. Stop. Petitioner alleges due to erection of stalls unauthorizedly on the pavement adjacent to the front side of the land of the aforesaid land of the petitioner, adjoining KMC Road, adjacent to KMC Road. Ingress and egress of the petitioner is being hindered, as a result whereof petitioner is being deprived of from enjoying the aforesaid land in question. Stop. Next paragraph. Writ petitioner, Kolkata Municipal Corporation, state respondents and respondent number 12 are represented by the learned advocates and who have been heard extensively today. Stop. During course of hearing, one order dated 18th April 2011 passed by the Honorable Justice Indira Banerjee, as her ladyship then was, is brought to the notice of this court, which is at pages 92 to 94 of this writ petition. Stop. Next paragraph. The relevant part of this of the order dated 18th April 2011 is quoted below. Page 94, first paragraph ta quote kore dibe. Next paragraph. Since the order dated 18th April 2011 attained finality, And in this writ petition, implementation of the said order is prayed for. This court finds it appropriate that the concerned authority of Kolkata Municipal Corporation is required to take necessary steps for removal of stalls from the pavements adjoining the front side of the land of the petitioner and KMC Road. Stop. Next paragraph. Mr. Alok Kumar Ghosh, learned advocate representing the Kolkata Municipal Corporation, has prayed for accommodation to obtain necessary instruction in order to disclose before this court as to when such steps would be taken by the KMC for implementation of the order dated 18th April 2011, passed by the coordinate bench. Stop. Next paragraph. Hearing of this matter stands adjourned till Monday next, 15th January 2024, when it will appear under the same heading, in order to enable the Kolkata Municipal Corporation, in order to enable Mr. Ghosh to obtain instruction. Yes, Mr. Ghosh, come back.
The report has been taken.
Yes, yes, it is taken on record.
Lordship filed two oppositions, Your Lordship. That may be taken on record.
Two, next paragraph, affidavits in opposition to the applications for
Can 2 and can 3.
applications for addition of party
Can 2 and can 3.
filed by the writ petitioner are taken on record.
But copies have not been served upon us. I don't know whether it's relevant.
It is not required.
Judgment, I don't know what to do.
Mr. Ghosh, come back. The long pending issue. Don't take technical points.
No, no, I'm not raising any technical, but I'm just asserting.
Being influenced by the clerk.
Opposition file করছে অ্যাডিশনাল ক্লেমকে ফাইল করি petitioner হয়ে
Grant prayer if
ঠিক আছে অর্ডারটা আসলে
and he passes the judgment so that we can also take advantage.
Yes.
That
Yes.
জানায়নি কিছু জানি না
They have a right, of course.
জানালে তো কি অর্ডারটা অর্ডারটা কি দিয়েছে না দিয়ে কি দিয়েছে
একটা ফার্দার ইন্সপেকশন করার কথা কি করে করতে বলেছে সে কি
With regard to possession.
আমি কথা বলছি
Whether it can be done in a writ proceedings or not. So that we are armed.
On that score, let this stalls be removed. On that score, I will hear it.
বলে দিতে হবে এই দিন ডিপার্টমেন্ট অ্যাকশন কোঅর্ডিনেট করে
Lord, I am for the petitioner in this matter. On the last occasion, on 11th of December, your Lordship was pleased to direct the municipal authorities to inspect the premises afresh by constituting a
Just a
team.
minute.
Watch this. Oh,
যাই হোক যা জানানো আছে
আজ আমি লিখে দিচ্ছি
রিভার্স
এটা
Yes.
The team was directly to be constituted with the persons of three departments. The things have not been done, but as the complete has not done because the team of the persons of the to be constituted.
Yes.
Therefore, my office asked for press for some more time to submit the report.
Only thing is this, their contention is this, that if the tube oil is installed and asphalt road is made without encroaching the premises number 9 Guru Saday Road, that is not possible. But previously a report was filed where it was disclosed that without making any encroachment, so far 9 Guru Saday Road, Kolkata is concerned, this asphalt road and installation of tube oil was made. So to that extent, this court wants a fresh report because a specific point has been urged before this court that if that tube oil and road is to be repaired by asphalt, by making asphalt road, in that event, 9 Guru Saday Road has to be encroached upon. Has to be encroached upon. That is the contention of the petition. Now, if you can demonstrate that it has not been encroached, then the effect would be different.
Actually, one of the property line is to be ascertained. Property line to be ascertained. Whether the
That's why I have directed the municipal commissioner.
The encroachment has been made or not. And whether it is his property, I don't know whether he could ascertain his own property. If he says, this is my property, then the question comes whether it is.
But there is no dispute regarding my ownership.
No,
it is my property. They have encroached. They have prepared. They have constructed the road. They have.
Question of ownership right while disputing. He said
Lordship has considered the report twice.
The side of the road. That is, I am submitting. If he says that this is my property line. To this extent of that. Up to the property line.
There is no question of property line. They have straightway entered my premises.
To the extent possible.
It is not that bound. Yes, it is not a question of boundary line as Mr. Ghosh is trying to place before your lordship. It is not the case. The case is they have straightway entered my premises. They have constructed the asphalt road. They have installed the street light and tube oil. These are the things. So that is why your lordship has been pleased to consider the earlier two reports.
If it is their property, if it is petitioner's property, then what was the necessity of making asphalt road and tube?
That is my case.
It happens, the land lies in the vacant condition situation. It could not be ascertained whose property actually his property belongs.
So therefore file a detailed report.
Yes.
In order to
that is the reason
disclose the situation.
I'll definitely come with a report.
They are asking me no time, and I am not
It is also necessary to ascertain the demarcation of the property line of my land event. Because if he cannot draw, this is my property line, beyond which my lord he cannot have any right. He is simply saying because the asphalt road has been made, therefore it is within my boundary.
So do you want to, before preparation of a report, or do you want to hear the petitioner?
It may be necessary because one of the ultimate.
If they want any assistance from us, we will always give that.
Yes,
there is no difficulty.
Then there is no difficulty
for further. But let the team go there. If the team is asking for anything,
but I have already directed.
Yes, the order is already there.
Inspection direction for inspection.
You should do that, my lord, and extend the time and with the
yes, any assistance. If any assistance is required, because order is already there.
I will extend the time, but in addition thereto, there is a direction for inspection.
That would be done by the by the team of the three departments. That will be done after that. When the report to be submitted by the municipal commissioner, you will be given a hearing. To complete
very well, let them hear you.
But as your lordship, I am not standing in way.
The report comes to the
whatever assistance they require, I will definitely.
Learned advocate, at the time of call, learned advocate Mr. Alok Kumar Ghosh, learned advocate representing Kolkata Municipal Corporation, has prayed for extension of time to file a report in terms of the order dated 11 December 2023. Stop. However, Mr. Ghosh has said, in order to demarcate the property of the petitioners situated at 9 Guru Saday Road, Kolkata, a personal hearing of the petitioner would help the concerned authority of Kolkata Municipal Corporation to prepare composite report. Stop. Next paragraph. time to file report as prayed for on behalf of Kolkata Municipal Corporation stands extended for 3 weeks.
Regarding Gazmi Forest time, if they say my land will be heard after the report comes to the municipal commissioner, he will be called before the municipal commissioner to
Stands extended for 4 weeks. Stop. Before preparing a final, before preparing the report, municipal commissioner shall be at liberty to hear the petitioners. After sending due notice. Stop. Next paragraph, list the matter under the same heading for further consideration on. February 2024.
12th February. Deep level.
Yes.
Madam, led by Mr. Basu.
Yes.
Deep level.
Next. Hey, yeah, Viplov. Yes.
Yes,
Where is the land advocate representing the municipality?
my lord, Arijit De, Mr. Arijit De.
Where is
but
he?
He is not appearing, my lord. And I served the order again to the school authorities. And SDO is, my lord, being the president, perhaps the state representative legal, maybe.
So SDO is the president of the school. What is the stand of the school?
Report already.
Have you obtained any instructions?
This is the old matter, my lord. There is no written instruction, my lord. But according to the report, it is circumstances.
What report?
And let it be filed by way of a report then. What is the present status and
report?
what are, this is only the papers.
Because sub-divisional officer
President.
has filed any report.
No.
So let me direct the sub-divisional officer to file a report.
Yes.
Which sub-divisional officer?
My lord, Barakpur. He is now the president, respondent number 9.
You have not received any instruction.
That
report already sent by the
What report? It's a documents, nothing.
documents.
And court will go through the pages. Take it back.
Lord, you kindly direct the
Take it back.
file a report.
For it দিয়ে দাও. Where is Mr. Arijit De?
Yes, I know what it is there, my lord. He was directed to take the instruction particularly.
Yes.
Why it was not Suomoto, it was not step
How the
one.
plan was sanctioned?
Yes.
By
Without my
keeping the
consent.
owner of the land in
Yes,
charge.
yes. And without
They
my lord, the requisite papers also, which are required to be submitted in as per statutory rules.
At the time of call, no one appears for Poranagore to issue.
Yes.
Yes. What instruction you have received
But
with
the
regard
instruction
to
I have
sanctioning plan?
Sanctioning plan, there was a plan sanctioned in the year 2003.
How?
Subsequently, may I say this? Subsequently, that has been, my lord, extended from time to time. Now, my lord, I have found from this report, my lord, there are certain, my lord, facts, my disputed facts which are to be gone into by the municipality. But subject to your lordship kind consideration, of course, your lordship pleasure, my lord, may I just beseech your lordship to, my lord, direct the municipality to initiate proceedings, and after initiating proceeding, my lord, parties will be heard and a reasonable order may be passed by the municipality. Because there are facts, my lord, there are facts which are to be taken care of by the municipality.
Which proceedings is to
220 bracket 1. 218. 220 is the stopwork. 218 demolition is 280. There are two things, but she says that there is a sanction plan which she is not aware of. But she has made an RTI. Now, before the municipality, asking the municipality to supply her a copy of the sanction plan if there is any. Now, Malad, I have checked up. There is a plan. Now, Malad, she says that that is being done without her consent because she is one of the owners and her consent is required. So, Malad, these things have to be gone into. Now, Malad,
Now, is there any parameter provisions as it is there under section 397 of the Kolkata
yes, that I
Municipal
said on the other
Corporation
day
Act?
there is one.
Cancellation of
Cancellation plan, there is one.
under which provision?
197.
देखिए,
197
Bengal Municipal
आगे दिन मैं check up.
270.
Oh, 270. Last day I placed that before your lordship.
But when let the municipality submit because there is no such fact to be gone into. It is clear statutory provisions are there.
Section 217.
Yes. देखिए 217 Yes.
Anytime sanction.
Yes, that is on the basis of material misrepresentation or fraud. That is similar to that Corporation Act. তাই তো fraud আছে তো fraud আর ওটা আছে তো হ্যাঁ এই তো fraud and misrepresentation same thing.
My lord, in my petition, it was categorically averred that the chairman of the municipality was at that present time was the president of the school. একটা রিপোর্ট ফাইল করো না যা বলতে চাইছে আসবে আরে দূর ওটা তো স্কুল সেটা তো এফেক্টেড হয় অ্যাকুইজিশন তো এফেক্টেড হয়
এখানে খেতে কি হবে যা করে আমি সেজন্য বলছি ওখানে একটা রেজিন অর্ডার দিলে সেটা তোমাদেরই সুবিধা হবে এখানে রোজ রোজ এসে কি রিপোর্ট ফাইল করবে 10 বার সেই রিপোর্টে এক্সেপশন কিছু তো করবে কিছু তো একটা করবে এখানে কি করবে এখানে ক্রস চেক তো স্টেট ওয়াইড ডেমোলিশন
The Board of Councillors has got the
power under 2017.
So you have prayed for cancellation of this plan.
Yes.
So
yes.
very well, let them take
Yes.
initiate a proceedings under section 217.
Yes, and the parties may be heard and it is
giving opportunity of hearing to the parties.
But that is what my lord was paying before lordship.
My lord,
And till that order is to be till 1 week after the order to be passed, the status quo order shall remain in force.
My lord, only 1 week, my lord, because municipality, my lord, because the concerned councillor is willing to grab the property.
No, those
My
things,
lord,
my lord, your lordship in a reach court, how can your lordship go into all that, my lord?
Report be filed by the
No, it's not required. Let the municipality take.
Yes, let them. That was
one thing. My lord, let us, my lord, go through the rules. There is no scope for further. My lord, kindly allow me, my lord.
No, your contention is that you are the owner of the property in question. Without by keeping your the petitioner in dark,
Yes.
the sanction plan has been accorded in favor of the school.
Yes.
Muko Bodhir,
Yes.
Mukbodhir Vidya Mandir.
Yes. Yes.
Now, if anything has to be any steps has to be taken, that has to be in terms of section 217.
My lord.
Since the plan has been sanctioned, construction has been made,
Yes.
without initiating a proceeding under section 217, how this can be done?
Yes, that obviously, but my lord, in the statute.
No, but my lord, sorry.
Are required to be, and those were not found, my lord. So let them file one report that what are the documents. Then, my lord, let the proceedings be.
Whether the plan was sanctioned in favor of Muko Bodhir Vidya Mandir.
And my lord, kindly allow me, my lord, because
The writ petition is heard in presence of the learned advocates representing the petitioner, state respondents and Boranagar municipality.
My lord.
Stop. Next paragraph. The grievance of the petitioner is without informing without informing anything relating to according sanctioned plan in favor of Muk or Bodhir Vidya Mandir, in favor of the authorities of Muk ও বধির একসঙ্গে বুঝলে মুক ও বধির বিদ্যা মন্দির within bracket previously known as Shambazar Shambajar Deaf and Dumb School, close bracket. Sentence টা পড়ো তো।
Because of he was performing and body section in favor of authorities of the justice Januuary Shambajar he conduct.
In 2003, a sanction plan was granted in favor of the aforesaid institution, in favor of aforesaid institution. Stop. It has been submitted by Ms. Bhattacharya, learned advocate representing the petitioner, that since petitioner is the owner of the land in question, without formal consent being given, no such plan can be sanctioned in favor of the aforesaid institution. Stop. It is also submitted that based on such sanction plan, construction has been made. Based on such sanction plan, construction has been made. Stop. Next paragraph. Mr. Orijit De, learned advocate representing Boranagar municipality, has drawn attention of this court to the provisions of section 217 of the West Bengal Municipal Act 1993, which postulates initiation of a proceeding for cancellation of plan sanctioned in favor of any person/authority if such plan has been accorded in consequence of any material misrepresentation or fraudulent statement. Stop. Next paragraph. Having considered the grievance made by the petitioner in this writ petition and the authority which has been conferred upon the Board of Councillors of the municipality under section 217, it would be apt to direct the Board of Councillors to initiate proceedings under section 217. Stop. Next paragraph. Accordingly, the writ petition stands disposed of by directing the Board of Councillors of Boranagar municipality to initiate proceedings and conclude the same after granting opportunity of hearing to the petitioner and private respondents, including the concerned subdivisional officer, Barakpur, concerned subdivisional officer Barakpur, within a period of 16 weeks from the date of communication of this order. Stop. Next paragraph. The status quo with regard to the building as the order of status quo with regard to the building in question as passed by this court video order dated 11 December 2023 shall remain in force till fortnight after the final order to be passed by the Board of Councillors shall remain in force till fortnight after the order to be passed by the Board of Councillors in terms of the order passed by this court today. Stop. However, there shall be no orders to cost urgent Xerox. আচ্ছা আপনার এই জায়গাটায় কি বললাম বলো?
Nowadays there are obligations caused by this court, void order, video order, and such and such remains in force till fortnight after the order is passed by the Board of Council in terms of the order.
Board of Councillors and communication of the same.
Now in another they might have allow me to communicate my address to the where the notice is to be served.
That you will implement.
Communicate your notice order. You will indicate that.
Next.
But regard to that construction, but inspection was made and it was very full and Probably now nobody will go and consider. Deal on it.
Yes. Lord, kindly committee Lordship's order dated 25th August 2023. Kindly goes through that order, Lord, then I'll start my service. So we place it for your Lordship's, Lord. Just a minute. Yes. So, Lord, if I may invite your Lordships to page 2 of your Lordship's order, my Lord kindly sees, my Lord, the last sentence of the first paragraph, applicants as it appears pray for demarcation of the holding number 49A, so and so in view of the aforesaid position, this court doesn't find it necessary separately to consider the application, keeping the writ petition pending, then kindly take the last paragraph. Before filing affidavit, it will be open to, so far, Kolkata Corporation is concerned to inspect aforesaid premises in order to disclose the correct location of the premises in question. But they made an inspection. Lord, then in the subsequent order, you will also directed them to file the affidavit. Time was extended. Now, Lord, if I may invite your Lordships.
Now affidavits are complete.
Yes.
Yeah, sir, my lord, I will send the confidence. We gave March, I will do Lordship, because it took much time. I already have filed myself, but no reply I did.
Reply down. You have served. देखिएगा অতীশ কুমার বিশ্বাস ওকে দেখি দাও অতীশকে দেখি
ঠিক আছে প্রকৃতি স্বীকার করো আমরা উত্তরাও দিয়েছি
Mana takes up the writ petition for a moment. Lord, I will not trouble your Lordship with the other thing. Lord, I will be very precise on the affidavit of the corporation. Lord, the basic issue before your Lordship is, Lord, 49A and 49 by 25. It requires demarcation. What happens, I tell your Lordship, Lord, my predecessor, they purchased the property by two deeds, one of 89 and the other one is 93. I'll take your Lordship to that. Then I purchased the property in 2008 and 2009 from my predecessors, who purchased in 1989. 49A. Now, what I found is, after the private respondents, they not came into picture, Lord, they started claiming that not my property is their property, which is not number as 49 within bracket 25.
But it is described in my order P25 within bracket 49.
25, 49. I'm sorry, not for, I was just saying the opposite. No, not the issue.
Now the private respondents are claiming that
on the same
that
property.
49A is their property.
They are claiming that they own 25 by 49, which is exactly what 49A is situated. It is the one property renumbered twice, given two numbers, and two parties are claiming title. All disputes are created by the corporation.
Who are you?
Lord, I am the owner of 49A.
Oriental Nilman
Yes.
Private Limited.
Lord, before I take your lordship's writ petition, I will invite your lordship to take out the affidavit of KMC. Lord, just one document.
Construction company.
Yes. Lord, kindly take the affidavit of KMC. Take the affidavit of KMC. I'll take your lordship later on to the writ petition. Just have a look at the affidavit of KMC. Keeping in mind your lordship's order that they will not inspect so that demarcation could be not done. Take the affidavit, Lord. It is affirmed by Lord HON'BLE Lahiri. My lord has kindly got it, Lord. The back seat is of Lord Mr. Atish Biswas.
Yes.
Now let's straightway come to page 12. Sorry, not sorry, page 9. Now kindly see, this is the copy of the IB book. Not inter IB with respect to 194/95 premises number 49A. So according to the record of the corporation, there is one premises 49A. Nobody denies that. Kindly turn the page. Kindly come to page 10. Let's see the second entry.
What is page 9? IB book.
IB book. Kindly take page 10. Copy of the IB. Page 10, second entry. 49/5 was made 49A.
Second entry.
Second entry, not this one. First entry, second entry. This one. Sri Sonir Chakraborty, art and art plus land. So and so, Nili Alipur. The entry below that. Area 6 Katra 4 Chatak. Then blue, so and so, sale price number so and so. Then accepted vide the order dated 28th November 1993. That was the date of my deed, my predecessor's deed. Malaras kindly got it. So the entry was made in the name of my predecessor. Then we kindly come to
what you have prayed for in this writ
but
petition.
I have said that the premises demarcated, the plan sanctioned on my building on which he made construction has to be cancelled and the construction has to go.
That must be based on demarcation.
That must be based on demarcation. Demarcation is the key thing.
Between the private respondent and yourself.
No, the dispute is created by the corporation. I am showing it to you, lordship. Let me show it to you, lordship. Not just bear with me for 5 minutes. I'll show it to you, lordship. They created the problem. But now kindly take page 13. And with regard to suit, long back I filed a suit and got a degree. Long back I filed a suit and got a degree. Now take page 13. My lord has kindly got it. Below page 13.
Yes.
Page 13. Let's see the first entry. 49A, land plus hut, Sonir Chakraborty.
One thing is that if both are claiming the same premises, then the right of the interstate parties has to be decided.
Right of the parties are already decided in a suit filed by me long back decree.
To take steps for based on the degree.
Not that is a declaratory suit that I got the degree, land belongs to me. Now, if the corporation in my land gives a separate premises number, mutates it, grants a sanction plan, on the basis of that sanction plan, someone.
What order you want from the writ court?
But the order that I want is cancellation of the plan that is sanctioned by the corporation on my land.
Then initiate a proceedings under section 397. Decide the issue, pass an order.
Whatever change was done, that was done long before filing of the suit. I was not very party in the suit, as it is rightly found by lordship my law. If really there is a dispute between the private parties claiming the same property as their.
No, Mr. Chakraborty is submitting that today that he has obtained a decree which is a declaratory in nature. That's why execution is not possible.
Yes.
So therefore, but it has been declared. Now, in ignorance or without considering this decree, you have permitted the private respondent to make construction upon granting sanction plan. Now, petitioner is challenging this sanction plan.
The kindly have to say non-con. If it is purely declared, it is not maintainable. What is the consequence? Certainly he has right to execute that. But I should not say anything on behalf of the other side.
No, but the right of the petitioner has been decided in that suit.
Nothing has been decided, nothing has been taken, your lordship. What is the suit? What is the relief? What is the contention there? Because that particular change, that was over 2001, suit is filed in 2010.
But it has been decreed in favor of the plaintiff.
I'm not party there.
May I,
Don't as a party.
may I just add?
So at a time of granting sanction plan in favor of the private respondent, whether this decree was taken care of.
My lord, that was long back.
Yes, but that the decree should have been placed before the concerned authority of the corporation.
They produce all these things for the corporations. The degree.
So then you initiate a proceedings under section 397, pass an order.
I don't mind. If your lordship so desire, I am bound by that. But the question is legal right. What is asking?
And whatever documents and the right which emanates in favor of the petitioner, that will be decided by the corporation at the time of considering the legality of the plan sanctioned in favor of the private respondent.
I've got something. Anybody
Yes, Mr. Chakraborty.
Lord, if my lord gives
This
me.
court at this stage cannot decide this issue. Sorry.
No, not at all, not at all. Just
let a proceedings be initiated.
Absolutely, Lord. I completely bow down to lordship. I completely bow down to lordship. But if my lord gives me 2 minutes time, Lord, to explain little nuances that I want from your lordship, Lord, let them decide on the plan. But before that,
No, what is the harm if I today how you are affected?
So that is what I'm asking. I'm not saying that it is harmful. What I'm saying is to give me complete and substantial justice. What they need to do is they need to first demarcate, then look into the plan. Lord, may I just forget about the litigation?
Demarcation over the same property is not possible, Mr.
Yes.
Therefore, it appears from your submission as well as from the records, the same property has been. You are in effect you are claiming demarcation of in connection with two premises in respect of a one property. That is Sonar Pathor Bati. If that is an oxymoron prayer. It is not possible. Now, what is possible is this, whether the plan which has been sanctioned in favor of the private respondent has been rightly sanctioned or not, in consideration or in acknowledging your right over the property, that to that extent, a deliberation can be made by the corporation.
I completely, absolutely, 100% bow down to your lordships. Lord, since it is falling from your lordships that I am asking for Sonar Pathor Bati, if I may use this from taking a cue from the court, that I am asking, why I am asking for demarcation. But why I am asking for demarcation purposefully, so that the corporation comes to a finding that it is one premises, not two.
You have to deliberate before the authorities, municipal commissioner, or the appropriate authority of the corporation under section 397 and that it has been wrongly sanctioned in favor of. It has been wrongly sanctioned.
Sanction.
Yes. Now, if the plan goes, then both the parties fight out before the.
I get everything, but what?
Once we say there was a demarcation of the land where other person is claiming, what is what course will be taken? Civil suit. Declaration that I am.
That's true.
But once he claimed that it was a demarcation, with whom? Respondent. I am not a party. I am not something legal right to the property. So if there is so, my lord very rightly said, Sonar Pathor Bati. What you are asking here?
One property, you are paying for demarcation of the property between the petitioner.
Someone has to agree that it is one property. Someone has to agree it is one property. So the corporation made the first mistake by giving it a separate premises number. I will show that right now.
To that extent, I will grant you opportunity to participate in a proceedings because
proceedings for what? If I may ask
the outcome of the conduct of the corporation is sanctioning of plan in favor of the private respondent.
May I beseech you,
This plan was sanctioned in favor of the private respondent or not? Yes, that is to be considered by the corporation afresh, and you will place your decree and other documents which you are relying upon.
Lord, may I say one thing apropos to this? When the corporation will take up the plan for cancellation, their submission would be it is sanctioned for 25/49, not for 49A. Their defense, if I was their lawyer, I would have said only this, that I got this property, this is my premises number, I got the plan. I will beseech Mr. Banerjee to allow me 2 minutes time. So that will be their stand. My stand is, corporation is also saying the same thing. My stand is, I purchased this property 49A. Not the first dispute created by giving it a separate premises number. So if the corporation start deciding, they will have to first decide on that, then the mutation, then
Whether the
cancellation.
corporation can, without demarcating the property,
That's the
how this you take this point before the
No, you will also direct them.
court will not say anything.
But if minor doesn't direct
Take
them,
this point.
if minor doesn't, not kindly, not kindly.
One thing is that
Not kindly, only one thing.
one thing is that
Let me just show one page. Not if I don't show this page, not you also process the order. Just allow me to show one page of the corporation's affidavit. Take note page 13 and 15. Then my lord passes the order. So page 13. Then 15. Yes. 13 you lord kindly see the first entry is Sumit Chakraborty. Then kindly see on the left hand side, change of owner's name, white, case number so and so of Oriental Nirmal Private Limited. So from Somir, it came to Oriental Nirmal by a particular case. By a particular case. Now, my lord, this is with regard to my entry. Now, kindly take page 15. 15. My lord, kindly got it? But kindly see at the top a little bit of hazy writing. This is the case of Suomoto assessment and the Suomoto mutation of so and so. Now kindly see on the left hand side 25 within bracket 49. Now details of assessment 21 so and so.
49 is their property.
According to me. Now existing details on third quarter 2001. Now this Dhansiri, they purchased the property on May 2002. According to the corporation, on third quarter 2001, Dhansiri's name was reflecting. How is that possible? Dhansiri got the property, the deed is annexed page 10 of the affidavit of Dhansiri. They got it on 16th May 2002. Maybe on the fourth quarter of 2002. Corporation says existing details on March 3, 2002, third quarter 2001. Now kindly see what they are saying.
You have prayed for in the writ petition.
Yes, Lord, I have prayed for in the writ petition is.
See first.
Kindly see
Things are being said.
my prayer in page 29 and 30. My prayer is not.
Just a minute.
Prayer B, kindly see. If it is same, no plan could be sanctioned. If it is not same, then I have no case. Dhansiri suddenly appears.
Just a minute.
জজ বলছেন তার সঙ্গে রিনাম্বারিংটাও দেব তাহলে আমার কোনো অসুবিধা নেই দুটো একসাথে let them also consider renumbering and mutation and sanction. না না আপনি অনেকদিন থাকলাম
What is the contention in the suit? What is the degree judgment? We don't know anything.
But the prayer is different, my lord.
আপনি তুমি আমার শেখার ক্ষমতা আছে প্ল্যানটা চ্যালেঞ্জ করেছি তো রোজিত We did not challenge the plan. Challenge করিনি এই তো প্ল্যান এই তো পারপোর্টেড স্যাংশন প্ল্যান প্লেয়ার সি প্লেয়ার বি এন্ড সি if it is allowed see that জজ সাহেব বলছেন ওরা ক্যান্সেলেশনের পজিশন সঙ্গে প্ল্যানটা দেখুক তাই তো corporation
Now, you are agreed by the according of sanction plan dated 4th August 2000.
Yes, that is their plan.
According to the private respondent, this plan was sanctioned
For 25/49.
Premises number P25 within
By
bracket
49.
49, Prince Ghulam Mohammad Sir.
I think it is on my property.
Now you want that this property be demarcated considering the position of these two properties. One is 49 and another is
But suppose
10 by 25.
if the corporation
Now the thing is this, that your contention is this, that without demarcation how this plan was.
Yes.
Now if you want purely a demarcation of these two properties, court will not entertain this.
Cancellation of plan, not to make demarcation.
Only
Not-
cancellation to the extent of cancellation, since you have couched a prayer under prayer C
Yes.
relating to the plan. I will
Yes.
direct the authorities to initiate a proceedings under 397 and decide whether the plan has been sanctioned, properly sanctioned or not.
No, Lord,
Matter
properly sanctioned or not, whether it is sanctioned with these two are one premises, if they don't see that, then Lord, they will say that it is for 25/49. That's what I said, it should be like 25/49, so you rightly sanctioned. But if on my property, today it is High Court, if I deny it as some other place and sanction a plan on your lordship's property, where the genesis is the renumbering of the property and sanction. Let
He would have risen or they stopped him. That's right.
Acha. Uh, can I not go to the court scene from here?
I appear on behalf of the petitioner. My lord, on the last occasion, my lords may kindly peruse my lord.
মিউনিসিপাল কর্পোরেশন একটু পরে দুটো এখানে রাখো না, আমার তো সুবিধা হয়, হাতের কাছে রাখো। হ্যাঁ থাক, তুমি এইটা এখানে রাখো।
Yes. Lord, my lords, on the last occasion, some orders were placed by Mr. Mukherjee, which my lord, your lordship was pleased to indicate.
What
my
were
lord,
those orders?
my lord, I have
How
brought,
those orders are relevant?
but my lord, I just
It's matter of seven, the order of the hearing officer. Of the hearing officer, the hearing was not done on a particular day and an order was. But there were 7, 8 dates when the matters were heard by the hearing officer. So I submitted before my lord the entire bunch of the orders, and also with that I have annexed the documents which were the subject matter of consideration by the hearing officer, which my learned friends client at the occasion to take copies, and it's their documents.
now, my lord, your lordship may kindly.
Subject matter, let's start.
Now, my lord, your lordship may kindly consider page.
Yes, page.
My lord, your lordship, the subject matter of challenge is the order dated 25/11/2013 of page 158 to 163. My lord, I have given a typed copy. My lord, if your lordship, my lord,
Type copy.
type copy, but if you because there are so many documents, I need not yeah, kindly excuse me. I have given some marking.
My bunch is at page 7. In my bunch, it is at page 7.
That's that orders which you filed last
Yes.
occasion.
Yes.
Page 7.
Page 7 of my bunch. It's exact xerox of what is there in the file.
Yes.
So, Mr. Mukherjee, compare page 7 with page 158.
But the first, this 25
is not a same page.
Sorry, Malad, I am sorry. Not 7, page 5 of that bunch. Page 158, what is there in 158?
Page 7. Page 5.
Yes, page 5 of that bunch. Now your lordship.
Otherwise, page 7 is not telling with page 1. It's a overwriting. Date is there is an overwriting so far date is concerned.
No, page 5. Page 5. 158 is equal to page 5 of my bunch.
Yes. Now, this is a typed copy of this.
I kindly excuse me. I tender my unqualified apology.
Yes, what do you want to submit?
Your lordship has already taken note of it. Your lordship was also pleased.
This is the final order of, this is the order which is under challenge.
Now, Millard, I tell you, lordship, Millard,
just RO means
recorded.
Owner. AAC Assessor Collector. Yes. What is the wrong in that order?
I'm grateful. Now, Miller, dear Lordship, kindly consider that there was no determination of objection under section 188 subsection 3. Kindly see 188 subsection 3. Miller,
189 subsection 3.
188 subsection 3. Kindly see, Miller, it would be better, Miller, if I start from 2, section 188 subsection 2. On the date, time and place specified under section 184 of section 185, and after giving the person filing the objections an opportunity of being heard, either in person or through an authorized agent, the officer appointed under section 187 shall determine the objections. Then, under 188 subsection 3, when an objection, yeah, I'm sorry, madam. I'm sorry.
So are you telling that you are not giving opportunity of being heard?
No, I am only indicating the point
In
that
in the backdrop of section 188 subsection 2, are you taking this point?
Willard,
that
I am
no
taking-
opportunity of hearing was given to
no,
you?
I am taking a point that this particular objection, Millard, which was filed by my client, this was not Millard dealt with, and Millard, this was also not taken note of because there is a statutory obligation. Kindly see,
How the-
I
in-
was
in that
Millard
event,
reading it.
how section 188 subsection 2 is relevant?
The time and place specified under section 184, 185, and after giving the person filing the objections an opportunity of being heard, either in person or through an authorized agent, the officer appointed under section 187 shall determine the objections.
Yes.
Therefore,
That is the deviation.
yes, the deviation is, Millard, kindly see that this particular, there was no determination of the particular objection. Kindly see the 2 and 3. Kindly Millard read. Millard, I appeal to my lords.
Now, 3 I will go later on.
Yes.
Regarding 2, it says on the date, time, and place without place specified under section 184.
And
after on the date, time, and place specified under section 184, and after giving the person filing the objection an opportunity of being heard either in person or through an authorized agent.
Yes.
The officer appointed under section 187 shall determine. It
Yes,
has been
determine
it
the
has been
objection.
determined
Yes.
after giving opportunity of hearing to the learned
No,
advocate.
I am submitting, Millard, that your
That
lord
is recorded in the order dated
Millard,
25th
kindly
November
see,
2013.
I'm just indicating to my lord. Then Millard, for a second, Millard, kindly come to Millard, subsection 3, 188.
Then section 2 is not relevant.
No, yes, 2, I am to place the objection and opportunity of hearing will be given.
That has been done. Previously, it was the Honorable Justice Harish Tandon found it that there was a dichotomy.
Yes.
With regard to filing, non-filing of objection and not taking the points as raised, not considering the points as raised in the objection.
Yes.
So
No,
that was
the yes.
And there was a direction to reconsider the objection.
Yes. Yes.
Objection has been reconsidered.
Yes.
Then there is a compliance
Now,
under
Millard, the
subsection
points
2.
which were
There is
taken
a
by me.
compliance under subsection 2.
Yes. If
Now, where is the aberration?
Yes. Now, your lordship may kindly consider that, Millard, the opportunity of being heard has to be given, and either in person or through an authorized agent, the officer appointed under section 187.
Given 25th
No,
November
I submit to my lord,
order
Millard.
Says so.
Millard, kindly
That,
see.
Mr. Vikas Goswami was granted opportunity to represent the petitioner.
Yes, yes, I am submitting that if they touch the objections which I have raised, Millard, kindly for a second, Millard, kindly come to 188.3. When an objection has been determined, the order in this
183. Yes.
When an objection has been determined, the order in this behalf shall be recorded in the register maintained under subsection 1 with the date, and a copy of the order shall be supplied within 30 days thereof to the person filing the objection in such form and manner as may be prescribed. Here, Millard, I very respectfully submit to my lords that this objection has not been determined. I did not find a single statement, and the copies of the orders, Millard, which Mr. Millard also handed over to me.
Your contention is this, that the procedure or in terms of the contemplation, in terms of subsection 3, there is no fresh determination of
There is no determination of
fresh
any objection.
determination
Yes,
of the
the
objection
phrase
in terms of Justice Tandon's order.
Yes, yes,
This is
yes,
your contention.
yes. And another point which I should be, because Millard, I should be candid to myself.
Then I have to again read this order in
Yes.
the backdrop of section.
No, Millard. Yes, Millard. And I just also, I say submit. I should be very respectfully submitting.
Now, Mr. Bhattacharya,
yes,
the annual valuation was fixed at rupees 9,34,160.
Yes.
With effect from second quarter 2008-2009.
My lord is reading the order.
Yes.
Yes, yes.
In terms of the impugned order dated 25th November 2013,
yes,
annual valuation was fixed at rupees 934,160.
Yes.
With effect from second quarter 2008-2009.
Yes.
Now, your contention is this, that this has been previously determined by the authority.
Yes.
By the hearing officer.
Yes.
Now, this was this is required to be determined afresh in terms of 188 subsection 3.
I'm grateful to my lords.
Now, while considering the order of the coordinate bench,
yes,
and the contemplation made under section 188 subsection 3,
yes,
is there any bar to come to the same conclusion after giving detailed reasons.
No, I am grateful to my lord.
Because determination is there,
Yes.
but the outcome is same.
Kindly see, what I could, my lord, recollect, after reading the brief.
And not only this,
Yes.
there are an observations
Yes.
that certain agreements were not produced before the hearing of
I have taken
petitioner.
the specific points. I'll be.
There's a suppression.
No, Milord. I say, Milord.
So
This
in
is
that event,
Yes.
in that context,
yes.
why this court will entertain the writ petition
Milord, I
when,
submit.
when there is a specific provision to prefer an appeal?
Milord, I'm answering. I got
Why
that.
this privilege would be given to you?
Yes. Now, Milord, your lordship may kindly come to Milord. First of all,
Are you contradicting these observations or these reasonings?
Yes.
As contained in the order dated 25th November 2013.
Milord, I have gone and challenged the legality of the action of the order dated 25/11/2013 on the ground of non-compliance of the statutory provisions. And secondly, kindly come.
Where is the violation of statutory provision?
Milord, kindly
let
come
us
to-
read it.
Yes.
Read the provision simultaneously.
Yes.
When an objection has been determined, an order
Your
in
lordship
this
is taking.
behalf,
Your lordship is taking.
you are laying emphasis on subsection 3, 188, subsection 3.
Yes.
Your
objection
case
has been
your
determined.
case hinges upon section 188, subsection 3.
Yes.
So let us read it simultaneously.
Yes.
When an objection has been determined,
Yes.
the order in this behalf shall be recorded in the register maintained under subsection 1 with the date, and a copy of the order shall be supplied within 30 days thereof to the person filing the objection in such form and manner as may be prescribed. So these are the procedural aspects.
Yes.
You are only concerned with the first part of subsection 3,
Yes.
which says when an objection has been determined. Your contention is that there is no ostensible determination of the objection.
Yes. I am
But I do
submitting.
not find so.
Milord, I
Not a
submit to
determination
my
of the
lords.
objection.
Yes, I submit to my lord.
But you have to demonstrate that why this reasoning is bad.
Yes.
Now, at this juncture, while this writ court will entertain,
No, I am submitting.
when there is a provision for preferring an appeal,
I have shown to my lords. My lords may kindly consider on the.
you are only, Mr. Bhattacharya, you are only concerned with this part of subsection 3, which says that when an objection has been determined.
Yes.
Your contention is this,
There was
that
no
that
determination
objection
at all.
has not been determined.
Yes.
But on consideration of the gamut of the issue, it appears
Yes.
that there is an order of a coordinate bench.
Yes.
Coordinate bench directed that there is a dichotomy. In one hand, you are saying that there is non-filing of objection, and other hand, you are saying that it has not been properly
Yes.
points are not properly taken.
Yes.
As it appears from the order of the coordinate bench, if you come the relevant.
This is a page 94. The relevant portion is that
it is axiomatic to record.
Yes.
That on one hand, respondent contends that the petitioner did not file objection, but on the other hand, it is contended that the objection was not filed in terms of the relevant statutory provision disputing the proposed annual valuation.
Then,
so therefore, there is a dichotomy.
Yes,
there is a dichotomy.
Kindly, Milord,
that
I
then
appeal
the
to my
court
lords.
directed to reconsider the objection.
No, Milord, I should submit to my lords.
Yes, place it.
Milord, just Milord, if I may be. The effort mutually destructive stand is self-evident. It is one hand to say that no objection was filed, but it is quite different that though the objection is filed, but it does not contain a sufficient material requiring determination by the hearing officer under section 188 of the said act. Furthermore, the written objection submitted by the petitioner clearly demonstrates the rate of rent received from the tenant, which is shockingly low. What has been proposed to be made by the municipality. There was sufficient material enclosed with the observation, with the aforesaid objection.
Enclosed with the aforesaid objection.
Yes, which is required to be dealt by the authorities while determining the objection. There was sufficient material enclosed with the aforesaid objection, which is required to be dealt by the authorities while determining the objection.
Yes.
Thus, I find that the hearing officer have passed the assessment order dated 20th December 2010 in a slipshod manner without considering the written objection and therefore cannot withstand the anvil of principles of natural justice. The appeal order dated 20th December 2010 is hereby quashed and set aside. Then this is very important. Hearing officer is directed to determine the objection filed by the petitioner afresh. Here, Milord, I place emphasis. afresh after giving an opportunity of hearing to the petitioner or his authorized agent and thereafter pass a reasoned order. Here this
Now,
what
if any, this is the, if any order or any objection is determined afresh
yes,
in terms of the order of the coordinate bench,
yes.
is there any bar to come to a same conclusion?
Milord, I say, Milord, if
There should not be any bar.
there is no bar.
Then where is the aberration?
I say, I submit to my lords, your lordship may kindly now come to the particular, my lord, points which I have taken in my particular written objection as well as, my lord, in the supplement.
I think, Mr. Mukherjee, only material which appears to me is relevant, that the which is contained in the order of the coordinate bench, is that there was a sufficient material enclosed with the aforesaid objection, which is required to be dealt with by the authorities while determining the objection. Now, where this dealing has been made by the yes.
Milord, I have not completed. Milord.
Yes, you have not completed.
Yes.
I acknowledge you.
No. Yes.
In order to have a grasp of
Yes,
the
yes,
issue.
yes.
Would straight away come to page 104. That is the paragraph of Madam Justice Tandon, what my learned friend was placing.
Yes.
Furthermore, on the top,
Yes.
the written objection submitted by the petitioner, the written objection what he has submitted,
Yes.
clearly demonstrate the rate of rent received from the tenant, which is shockingly low. What has been proposed to be made by the municipality. So, the rate what he has disclosed in his objection, we say that it is shockingly low, and my proposal is this. Now, my lord, I have.
So, considering the rate of rent, which is low in consideration of determination of annual valuation made by the authority.
What he has submitted. So, his first objection was.
But now the authority has considered the issue in the on the basis of 3 other agreements.
And it was given to them. Now, my lord, would kindly take my punch. My learned friend has started from.
So this determination of annual valuation was in the context of one agreement at the first stage,
Yes.
which was negated by the coordinate bench.
Yes. Now, my lord.
So in connection with one agreement, there was a determination of an annual valuation.
Yes.
Now the same valuation is made in connection with 4 agreements.
Which was suppressed. Now, my lord, the court directed that you hear the matter afresh. My lord, would kindly take my bunch.
Just a minute. If you take, yes, your bunch, yes.
Yes. My lord, the hearing started on 1st of April 2013. The first page, top.
Yes.
The hearing started on 1st April 2013.
That is after the order passed by the coordinate bench.
Yes. Now, your lordship turns over page 2. Your lordship would kindly consider the 15/7/2013.
Yes.
Which is not been given to my lord's writ petition. This is here from the whole thing starts. Deputy Assessor Collector and Assistant Assessor Collector are present. Sri Bikash Goswami represented RO as authorized representative. AAC, Assistant Assessor Collector, produced 4 numbers of agreement between BR Company, Raj Khosla, in connection with the fixation of the monthly rent of for 2 numbers of amounting 5,000. Then, my lord, the figures of this rental agreement are depicted for an area of 1,000, 2,000, 3,000 square feet. Other 2 agreements are of service amenities. My lord, these are all suppressed, amounting to 53,000, 70,000. Thus, the total amount of 4 agreements comes to 88,000 and the valuation has been based on this amount.
88,000. Valuation is based on total 88,000.
88,000 per monthly income. Now, AAC has stated that VR
So
company.
according to your calculation, 88,000 was the monthly income, which was not detected in the while passing the order, which was negated by Justice Tandon.
Now, Malad, he had only harped upon 5,000. 5,000, Malad, there is one 5,000. I have given those agreements, Malad, I'll just place it.
Now, no, in the order dated 25th November 2013, these are stated.
Yes. In that last order, I have given the details of this agreement one by one. Now, he was only harping on 5,000. So his objection, which was directed to be considered afresh, was relating only to 5,000. Now, after these three agreements, the parameter of consideration widened. Now, my lord, if your lordship takes 188.3 objections, that objection is redundant because that objection is related with only 5,000 rent. Now I have got 88,004 agreements executed, notarized. I place it before the representative who appears along with the recorded owner. Now, what does the here I have there is no objection that this statement or this recording is wrong regarding suppression. Now, my lord, if your lordship is kind enough to take again page 5, the one what my learned friend was placing, the order dated 25/11/2013.
Yes. Page 5, place it.
Yes. The first paragraph thereafter I'll go. Requested the recorded owner to submit his statement. Sri Vikas Goswami started to advocate in favor of recorded owner. Earlier, the recorded owner submitted the written objection and statement. So the written objection, what they were submitted, it was on record, but the parameter of that objection has changed due to this fresh development and
detection of other agreements.
Yes.
Yes.
Now, my lord, would kindly come to the next page, page 8. Here, my lord, I'll be placing only one paragraph, but in details. After hearing both the parties and going through
Where page 6?
Page 8, my lord. Your lordship was in page 7 earlier.
Page 8, yes.
Now page 8 from top. After hearing both the parties and through all the documents submitted by recorded owner and assistant assessor collector, the following points has to be kept in mind for consideration. The RO, recorded owner, did not furnish all the agreements during inspection. When the authorities went to inspect the house for assessment of annual valuation, they produced only one agreement, that is the notarial certificate number given, and thus suppressed the fact. They submitted objection against the proposed valuation to the hearing officer, KMC also. Well, this objection is based on 5,000. But today, this is very important, your lordship notes. But today, during hearing, both RO and his advocates agreed about the existing of all the above noted agreements.
How these agreements were detected?
During inspection.
In the affidavit in opposition, have you disclosed this?
During the affidavit opposition.
Kindly see the affidavit in opposition which has been filed with then not any particular indication is there with regard to either the objection or the supplementary objection or this. I
tell you, Malad, this is Malad from coming from Mr. Bhattacharya. I feel
no, but the court has to pass an order placing reliance upon these documents.
Yes, this is a judicial review of an adjudication order by a quasi-judicial authority. In affidavit,
I will grant you further, not in this fashion, Mr. Mukherjee.
Mohinder Singh deal is there. I cannot develop anything by filing an affidavit. what is there in the order. Your lordship has to go through by that order. I cannot add a reason. I cannot.
No, in your affidavit in opposition, if he is silent on this issue,
Order is clear. The order under challenge is very clear.
it has to be formally brought on record. Why you are feeling shy?
No, I can bring. My learned friend has annexed the order. The order contains everything.
No, you are taking this point that this previous order was passed on based on an agreement amounting to rupees 5,000 rupees. Subsequently, there was a detection or discovery of 3 other or 4 others agreements which enhance the valuation. Enhance the valuation. These things are to be stated in your affidavit of opposition.
So, my lord, with the deepest of respect.
File your affidavit, another affidavit.
I'll file that.
Additional affidavit in
Yes, I'll file that. I'll just
because we will pass on a final order based on these papers which are not part of the record, though affidavit in opposition has been filed.
My lord, pardon me. These are parts of record because my learned friend has given it in his written petition.
No, not in this way.
I'll give it.
I will not pass an order.
My lord, I'll give it. I'll give it because I'll give it, and these agreements, my learned friend, by filing a supplementary affidavit, has brought in on record.
The matter is heard to some length in presence of the learned advocates representing the petitioner and Kolkata Municipal Court.
Only one thing.
During course of hearing, Mr. Mukherjee has relied upon certain orders passed by the hearing officer.
Yes.
Passed by the hearing officers. After the order was passed by the coordinate bench while disposing of the previous writ petition by judgment dated 28 August 2012. Stop. It has also been submitted on behalf of KMC that the previous order which was set aside by the coordinate bench vide judgment dated 28 August 2012 was based on one agreement amounting to rupees 5,000 rupees, but while while determining the issue relating to fixation of annual valuation of the property in question, certain other agreements were discovered, which shows from which it was found that
Possibly we are
while assessing the annual valuation,
possibly we are misleading the court.
while assessing the annual valuation,
Possibly we are misleading the court.
while assessing the annual valuation of the property in question, those other documents are required to be taken into consideration.
Just
Consideration. Stop. Since the affidavit in opposition, next paragraph, since the affidavit in opposition filed on behalf of KMC is silent on this aspect, which is being agitated before this court from the bar. From the bar, this court finds it necessary to grant another opportunity to KMC to file an additional affidavit in opposition. Stop. Let such affidavit in opposition be filed by 1 week, by 10 days from date, and affidavit in reply thereto, if any, be filed within 7 days. Stop. List the matter under the same heading for further consideration on in the monthly combined list of February.
Only one thing which I was indicating, kindly see page 87. That was the first order. The order which my learned friend is indicating that there is a particular indication of rupees 5,000. I do not find anything mentioned in this order of 28 December 2010, which was before Justice my lord
28 November 2013.
Yes, I'm grateful to my lord.
Yes. What is 87, Mr. Bhattacharya? Subsequently, in the order dated 28 November 2013, you do not find?
My lord, I submit to my lords that page 87 is there in the writ petition. This order, this has been tested before the division bench of Justice.
Page 87.
Page 87. This is the order dated 28 December 20. I'm sorry. Page 87 is the final order.
Very easy to say that we are probably misleading.
My lord,
Agreement
monthly
But this order was
license-
put under challenge in your first writ petition.
Yes,
When the coordinate bench passed an order on 28 August 2012.
I'm full. Now,
Yes.
Miller, kindly see this. What I want to indicate, which judgment was passed on 28th of August 2012. Now, Miller, I find that these observations of this order that deals with order of 28th December 2010. Here, Miller, I do not find what was there. Kindly say only thing which has been indicated is that it has been seen that the particular has been for the purpose by the Kolkata Municipal Corporation on the basis of rent of rupees 86,496 per month. That's the reason, Miller. I wanted
Page 86.
Yeah, right.
Leave and license with effect from 31st.
Lordship has got
Yes.
in the middle. The agreement monthly of a license of 5,000
per month.
So this was the subject matter which was disclosed. Now, what was thereafter found was certain checks. Accordingly, it was submitted that the recorded owner is receiving this check. We, on the basis of hypothesis, corporation proceeded to determine the annual valuation, taking those check value as the rent value. Now, my lord, we have got the actual evidence, that is the agreement itself.
So why you have not stated these things in your affidavit?
Nothing has been stated. Nothing has been. Miller, kindly see the affidavit. It is one
You are
thing.
inviting this court at the final hearing stage to rely upon this document.
I just a reason.
Maybe, but from where, why at the time of determining, the issue on 1st of March 2010, the corporation decided on the basis of the single agreement dated 8 May 2008, and
Yes.
what basis subsequent 4 other agreements were discovered.
My lord, I apologize. Yes,
Can these things be ascertained from your bunch of documents?
in the order it is there. My lord, I apologize. Your lordship grants me a statutory authority. I have given documents. It is not that I have invented it from the sky.
But that it has to be on record.
I have given to my learned friend. It was shown
Maybe,
in the
but
recorded
what
owner
about
and his authorized
what about the procedure you have followed while discovering this
I-
subsequent agreement?
My lord, I apologize. I fully admit what
Disclose
My lord,
those things, Mr. Mukherjee.
I'll give it. I'll
Yes.
give it. As your lordship has directed, I will give it. My lord, within 8 days, I'll push it.
8 days, 7 days. Reply.
Yeah.
All the list.
My lord,
I'm praying for the KMC, praying for short pass over lord.
Let me see.
Lord, I'm also praying password. Mr. Obhijit Bosu is appearing in the matter. Mr. Obhijit Bosu, he is appearing there. He has another matter to some other court. So, my lord, I'm praying also password.
Have you served notice?
Yes, my lord, we have served within time.
Show me. Show me
Lord, affidavit of service not been ready because
Why not ready?
because my lord, we have served to private respondents, but your lordship had directed to all the private respondents who are working in the KMC. So we did not collect till we did not get information from the KMC till now. So
So you could not effect service upon the private respondents
my lord, we have served on 5th within time. My lord, your lordship
upon the
was-
private respondents.
not all the private respondents.
Private respondents.
Have you shared the details of the private respondents?
That has to be.
I have to go to the mutual.
Yes.
Whether he has served to the private respondents or not.
No, that is you are not supposed to know, but you are directed to share the details of the private respondents, which would facilitate the petitioner's advocate to complete the service upon the private respondents. There is a direction to that effect. In my last order, learned advocate representative petitioner is directed to serve notice upon the respondents of the learned advocate and private respondents within 1 week after Christmas vacation. List the matter. Kolkata Municipal Corporation shall cooperate with the learned advocate for the petitioners to effect service of notice upon the private respondents by sharing details of the private respondents who are not presently working in KMC.
They have the.
Why you have not shared the details?
The first item, the details have been.
There may be some difficulty. So why you are not cooperating with the petitioner in spite of court's order?
Subject to correction, they have not asked to give the details.
Court has directed you.
My lord, order has been annexed. I have.
Court has directed you.
2 days, no license.
Complete it.
Yes.
Issue. At the time of call, learned advocate representing the petitioners has prayed for accommodation to complete service of notice upon the private respondent. Stop. It has been submitted that the details of the private respondents in terms of the previous order dated 14 December 2023 would not 14 December 2023 were not supplied to the petitioner, were not supplied to the learned advocate for the petitioner, as a result whereof service upon the private respondents is not complete. Stop. Next paragraph, Mr. Panda, learned advocate representing KMC, submits before this, undertakes before this court to share details of private respondents within 2 days. Stop. List the matter under the same heading for further consideration on 15th January 2023 in order to enable the learned advocate representing the petitioners to complete service.
Great.
And file affidavit of service.
My lord, may I take back in that case?
Yes, yes.
Grateful.
Next.
Right to appear for the petitioner in this matter. On the last occasion when this matter was taken up by my lord, your lordship was pleased to
Just a
allow
minute.
my.
Just a minute.
Yes.
Yes.
My lord. Now, on the last occasion, your lordship was pleased to allow my amendment application, my lord, and directed me to serve upon the Kolkata Municipal Corporation. In compliance to my lord's order, we have served the Kolkata Municipal Corporation. Only,
Why
my
get
lord,
served upon municipal corporation? You should have served it upon Mr.
we could not get
Ghosh.
that. That is the problem, my lord, we are facing. We could not gather the particulars of the learned advocate.
It is
who-
there in the order itself. Dated
It's,
16 November 2023.
my lord, we kindly see for the KMC.
Yes.
KMC we have served, but there are three more municipalities, my lord. The respondent number 456. My lord, we kindly see my writ petition once. There's a chairman of the Bhattacharya municipality, Noihati.
456. Yes, yes,
Yes.
yes.
My lord, will kindly give a direction to serve them directly because we could not get the name of the learned advocates who are representing those municipalities. We'll serve them.
That you could have done by this time.
Could have done, my advocate. My lord, will kindly give me a formal direction. We'll serve them with the amended copy of the writ petition to all these three parties. Respondent number 4, 5, and 6.
Writ petition is taken up for consideration when the learned advocate representing the petitioners prays for accommodation to complete service of notice of this writ petition upon
R4, R5, R6.
respondent numbers 4, 5, and 6, including amended copy of amended cost title of the writ petition. Stop. List the matter under the same heading for further consideration.
In the meantime, if they want to file their affidavits, my lord, will kindly direct that also. They will file it, my lord.
On 22nd January 2023, in order to enable the learned advocate for the petitioners to complete service upon the aforesaid respondents and file affidavit of service.
Grateful, man.
Where is your affidavit of service in connection with service which is effected upon the corporation, Kolkata Municipal Corporation?
I can find, my lord, there's a letter, my lord, showing service, but there's no formal affidavit of service. If my lord so directs, my lord, we will
File
prepare
composite affidavit of service.
a composite affidavit. We'll do it, sir. Grateful. I'll go. Yes. Grateful, my lord. Nam.
Please. Issue. At the time of call, no one appears for the petitioners, and no accommodation is paid. Previously, on two occasions, 30th November 2023 and 14th December 2023, on behalf of the petitioners, accommodation was prayed for to take necessary steps in view of death of the petitioner. In view of death of petitioner number 1. So, next paragraph, it appears next paragraph, it appears heirs stroke successors in interest and three other writ petitioners have lost interest in the fate of this writ petition. Next, accordingly, the writ petition stands dismissed. Interim order, if any, stands vacated, urging the observation. Next.
Well, I am for the petitioner, you know. It is that petition where your lordship allowed the substitution petition for the widow and the son of the petitioner. The petitioner was an employee of.
Where is Mr. Ghosh? Is a matter relating to payment of pension?
Lordship. He was connected. He was.
Just a minute.
হ্যাঁ হ্যাঁ কি বলেন আরে সুমিত দাস
Your writ petition was dismissed for default? No.
No. Not dismissed for default. Your lordship, the petition
Substitution application was
allowed. Substitution petition allowed by your lordship.
you took time for filing substitution application.
Lordship. Along with section 5, because it was the substitution, the wife and the son was not aware of the petition filed.
Just a minute. পেনশন পেয়েছে
Provisional pension.
প্রভিশনাল Now, whether the order of Justice Munshi, as his lordship then was, dated 2nd February 2018, whereby it was directed that 2/3 of the pension and other benefits and provident fund accumulations are to be released, whether these are paid.
2/3 pension was given.
2/3 pension and other benefits.
Other benefits were not
This court directs the Kolkata Municipal Corporation to release the amount that is 2/3 of the total retirement benefits, not pension, total retirement benefit which the petitioner is entitled to in pursuance of his superannuation subject to result of the writ petition, the provident fund accumulation, whether it has been released.
And my instruction is because this lady, she was not aware of anything. As per her, what I got from her, the husband never used to communicate her regarding all these things. But what she instructed me that provisional pension, she used to receive a provisional pension till he was alive. 2019.
After that, nothing.
After that, nothing, because life certificate was
pay
not
provisional pay provisional family pension.
Now, now.
And have you paid the provident fund?
All benefits.
Show me you have paid. Because you have not filed any affidavit in opposition. Show me. You have paid the provident fund amount.
Because the lordship, the petitioner is the criminal proceeding is pending, but he has passed away. So there is no proceeding. So my lord, he is entitled to get the full pension, the gratuity, the provident fund, and all other retirement benefits. Even your lordship.
We are also not known about his death at particular point of time. Till Till he made the application.
My petitioner was called. The wife was called by the Kolkata Municipal Corporation, and he was asked to submit the after this. Your Lordship passed this order. No, after Your Lordship passed this order, it was communicated, and the concerned officer of the KMC asked her to come.
Call the successors.
And they asked her to submit the death certificate. It was submitted, and that was submitted in the month of December.
Yes. Then what steps you have taken?
In December,
And she was informed that as the matter is pending before High Court, until and unless there is an order from High Court, they are not in position to release all the benefits. That was she was said.
And, my lord, we have not yet received any instruction after December, my lord. But we are willing to pay the benefits which he is entitled to.
Why? Because already
we are
petitioner
not
has died.
Christian. All other benefits were paid.
Rest of the amount you are required to pay because petitioner has died. Now, therefore, the proceeding which was initiated against the petitioner,
Proceeding initiated.
only criminal
What
proceeding.
criminal proceeding?
No application has been made till today for claiming the benefit of the petitioners.
Writ petition is pending. Court is passing order one after another.
Never
For the during pendency of the writ petition, petitioner is required to file an application. Mr. Devnath,
we have not yet received any intimation so far, and after receiving the
you are
intimation,
appearing for the corporation.
Yes,
Yes, petitioner, the successors in interest and heirs have filed a application for substitution. That has been allowed. What further is required? Matter is pending. It is fixed for hearing in the monthly list of January 2024. And now you have not taken any instruction. You are taking the matter very lightly then.
Not like
For that appropriate order needs to be passed.
We have the application will be made. They will consider it and pass the.
Well, that was not the instruction.
Your learned friend is submitting that the heirs of the petitioners have been called by the concerned official of the KMC, and they appeared. And they submitted the death certificate and other particulars. So after that, nothing happened. Now there was no criminal disciplinary proceeding. Criminal proceeding was pending. Now, due to death of the criminal procedure, due to death of the petitioner, what remains? The petitioner, and in his absence, his successors are entitled to get the full benefits.
He will get benefit, my lord. The formalities which are necessary, my lord. I take instruction within 7 days, my lord. I will place before your lordship that how far his dues is concerned, he will pay the dues. And what he have to do.
And your lordship, one more prayer, your lordship, let them file a report because whatever pensionary benefits, retirement benefit paid, let them file a report, and when paid, there must be through a check or something like that, because the petitioner, the present petitioner, is not aware of anything. So, my lord, let them file a report giving all the details. So, my lord, she can at least check with the bank whether it has been received or not.
The petition is heard in presence of the learned advocates representing the petitioner and the Kolkata Municipal Corporation. Stop. The grievance of the petitioners. Grievance of the petitioners is non-payment of retirement benefits by learned advocates. Stop. Next paragraph. In order to give one more chance to the petitioner, hearing of this matter stands adjourned till Monday next, comma 15th January 2024. Stop. Next paragraph. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Once it was dismissed for default, again restored, then affidavit in reply.
My lord.
Yes, please.
Your Lordship, the copy has been served upon me now. Your Lordship, the affidavit.
What?
The affidavit in reply. Your Lordship.
Let him place this case. Yes.
My lord, this matter has been filed, my lord, against the wrong fixation of the annual valuation of my property. My lord, kindly see, my lord, at page 19, my lord, that a bill has been raised where, my lord, that is at page 19, my lord, P1.
Page 90.
Page 19, P1, my lord.
Page 19.
19.
Yes, page 19.
My lord, my annual valuation was 5,300. My lord, the annual valuation table, my lord, old annual valuation.
Where from here? I will get it. 1,300.
My lord, the old annual valuation column, my lord. The old one is, my lord, 5,300.
Annual value
rupees, my lord.
5,300.
5,300. And my lord, new valuation was 1,20,096, my lord, which is, my lord, 25 times, my lord, of my annual valuation.
Yes. Now, are you contending any other? Are you taking any other point?
My lord, in this matter, my lord, I
25 times enhancement of valuation.
Without giving me any opportunity of hearing. My lord, no notice has been served and no opportunity of hearing has been given. And then, my lord, after that, in P2, my lord, I have filed an application under RTI Act for, my lord, to get the information regarding the valuation of the property.
Yes.
P2, my lord, at page 21. I have filed an RTI application, and to that effect, my lord, a calculation has been given by P3, that is at page 29. Here, my lord, the calculation has been given. There is some anomalies, my lord. And my lord, moreover,
Where is that calculation?
My lord, that is the calculation in ground floor, my lord. The detail of
page that calculation.
That is the GR calculation of valuation are
Which page? Which page of the
at
fifth petition?
23, page 23.
Now, how this exorbitant enhancement of annual valuation from 5,300 to 1,20,096?
It is as in terms of.
And that too without granting opportunity of hearing to the petitioner?
Your Lordship, this has been done in terms of the general valuation, revaluation.
For that, no hearing is required. Show me the provision. Howrah Municipal Corporation Act.
Your Lordship, for that I have to refer to the records whether he was given the hearing or not. Your Lordship,
Yes.
we have taken a denial that
25 times enhancement of annual valuation and that too without hearing.
Your Lordship kindly takes my affidavit in opposition. Your Lordship, at page 12, we have annexed it's a P 1 5
Calculation will come later.
Your Lordship.
First, show that you can do this without granting opportunity of hearing.
Your Lordship, in that case, I have to see the.
No, have you taken this point that without hearing you?
My lord, I have
Where you have stated this?
My lord, page paragraph 5, that your petitioner states that without giving any notice and or hearing, the Howrah Municipal Corporation Authority raised a tax bill dated 15/11/2010 and 19/11/2010 fixing the annual valuation of the said property of property rupees 1,20,000.
Now, how this has been verified, dealt with by the in the affidavit in opposition?
Para 6, Your Lordship.
It's a reply.
Only denial, my lord.
Nothing has been stated with regard to the denial of opportunity of being heard.
Or the date of the hearing when the petitioner was served with the notice, Your Lordship. Your Lordship, a chance may be given to refer the record, Your Lordship, whether in fact we had given a notice or whether he
Very
could
welcome,
not
well.
appear.
My lord, they have filed their affidavit, my lord.
His only point is that there is a breach of natural justice, Your
Yes,
Lordship.
very important point.
Your Lordship, very important point, Your Lordship.
And,
For that,
and my lord, there is another.
Wait,
My lord.
yes.
if Your Lordship pleases to give a chance, Your Lordship, I shall refer the records and see whether any notice.
Whether at all this opportunity was given.
Given or not, Your Lordship, whether it
Let
was
him come
availed
back.
or
My lord, another point is, my lord, subsequently the Howrah Municipal Corporation itself reduced my annual valuation at 92,000 also without giving me any notice. And what is the reason for that? Moreover,
Where is that?
my lord, that is also in their
reducing the annual valuation.
My lord.
Your Lordship, that also has been dealt in paragraph 7, Your Lordship, of our affidavit. There was an order of the mayor, Your Lordship.
But your act says that opportunity of hearing needs to be given.
And my lord, the amount has been fixed.
The enhancement of annual valuation of the property of the petitioner situates at 14/12. Situates at 14/12, GT road.
4/12.
4/12 GT road. GT road, south within bracket, 4/12, GT road within bracket south, close bracket, pull.
The enhancement of annual valuation of the property of the petitioner situates at 4/12, GT road within bracket south.
Under Howrah Municipal Corporation is under challenge. Stop. The learned advocate representing the petitioner submits that the annual valuation of the property in question has been enhanced from 5,300 to 1,02,096. 1,20096, which is 25 times than the previous, than the old annual valuation, which is 25 times higher than the old valuation. Old annual valuation. Stop. Next paragraph. It is also contended on behalf of the petitioner that such substantial enhancement has been made in such substantial enhancement of annual valuation has been made by the concerned authority of Howrah Municipal Corporation unilaterally without granting opportunity of hearing to the petitioner. Next paragraph. The learned advocate representing Howrah Municipal Corporation has prayed for accommodation to obtain instruction whether opportunity of hearing was granted to the petitioner or not before fixing the annual valuation of the property of the petitioner at rupees 1,20096. Stop. Next paragraph. Hearing of this writ petition stands adjourned till Monday next, 15 January 2014, when it will appear under the same heading in order to enable the learned advocate for the HMC to obtain instructions. Stop. Next paragraph. Affidavit in reply filed by the petitioner is taken on record.
#72, I am for the petitioner, my lord.
My lord, I am asking for the respondent. My lord, I am filing the affidavit.
Expedient number 6 to weeks. So up to the Barasa police.
Affidavits are complete.
My lord, I am filing
Affidavit
my
in
affidavit
opposition
in
reply. Who is for the petitioner?
Well, I am for the petitioner.
And private respondent?
Private respondent.
Here you have filed your affidavit in opposition. Yes.
My lord, petitioner. My lord, petitioner praying for a implementation of the order passed by the Barasat municipality in compliance of the solemn order passed by this Honorable High Court. My lord, it is passed in 2014. After 2000
Order relating to
demolition of unauthorized construction made by the private respondent, respondent number 6. Now, my lord, in 2014, this Honorable Court passed in the previous writ application, passed an order directing the Barasat municipality to consider the representation made by the petitioner, alleging that private respondent to make a unauthorized construction. That petition is disposed of, directing municipality to consider and dispose of after inquiry. Inquiry made after giving fair opportunity of hearing. It was decided by the municipality that construction is illegal and direction given by memo to the respondent to demolish the said unauthorized construction. In 2014 itself, my lord, petitioner, respondent number 2 challenged the said order before this Honorable Court, challenging this order.
Order of demolition.
Demolition challenged by the respondent number 7 before this Honorable High Court in another writ petition, and that said writ petition dismissed on default in 2018.
Dismissed for default.
Dismissed for default in 2018. In 2018, petitioner again filed this writ application for praying for implementation of the order passed in 2014 by the Barasat municipality.
Where is that demolition order?
My lord. My lord, page 26. Page 26, P4. No, no, 20, it are previous. Page 26, P4. Page 26 to P3.
Yes. Yes, this demolition order was passed against your client.
Ujjal Mandal.
You are representing the private respondent. Then have you complied with this order?
Writ petition টা দেখো আমার
Page 26 of the writ petition.
My lord, I am paying for a time of 1 week, my lord. Actually,
Use microphone. Point the microphone to you.
my lord, I am paying for a time of 1 week, my lord.
Why?
My lord, in this matter, my landlord senior is engaged in this matter. My lord. Mr. Chinmay Pal. Mr. Chinmay
Switch
Pal.
on the microphone.
My lord, he is not present today, my lord. He is not present today.
Who is your senior?
Chinmay Pal, my lord. Mr. Chinmay Pal.
Chinmay
Pal.
Pal. 11. Where is he?
My lord, he is not present, my lord. I am just praying for not today, my lord.
Why he is not present?
Maybe
What has happened to him?
maybe some medical emergency happened, man.
Maybe you are not sure. Are you chamber junior to Mr. Pal? You regularly attend his chamber. So then why you are not sure about the indisposition of Mr. Chinmay Pal? Yes. When you have joined the bar?
Last month. Last 1 month.
Last 1 month. Then we need to give some accommodation. Issue. Matter is heard in presence of the learned advocates representing the parties. However, you know what is your name?
Archon Datta. Archon Datta.
Archon Datta. Party stop. Mr. Archon Datta, learned advocate representing respondent number 6. has prayed for accommodation. Stop. List the matter under the same heading for further consideration. On Monday next, 15th January 2024. Next Monday, but no further adjournment. Either you come prepared. Affidavit, who has filed affidavit?
My lord, the respondent number 6 filed affidavit in opposition.
Yes,
today.
yes, Mr. Archon Dotto. Have patience to hear the court till your matter is over. Don't leave the court in this fashion. Who has filed affidavit in
Respondent
opposition?
number 6 filed the opposition and petitioner filed
Affidavit in
the
opposition
affidavit
filed
in
by the
reply.
respondent number 6 and affidavit in reply filed by the petitioner today are taken on record.
15.
January.
Item 73, I appear for the private 9 to 3.
I
appear on behalf of the added
In matter, my lord, I bid to appear on behalf of the petitioner. There is a protracted history of litigation, number of rounds. My lord, it's a construction made on a pond. And my lord, while filling up for my lord, under rule 4, my lord, they are very categorically stated is a solid land. By way of RTI and by the direction of this honorable court, Kolkata Municipal Corporation supplied certain document which shows that they are very categorically said this is a solid land. Though my lord, the BL and LRO record says it is a pond. Thereafter, my lord, first round litigation, second round litigation in the division being my lord, the Kolkata Municipal Corporation preferred one appeal against my lord, the direction issued by the Honorable Writ Court to look into the matter under section 397 by the Kolkata Municipal Corporation. When the matter was pending before the division being, there is a direction to the BL and LRO to file a report. That report was filed. Report says, my lord, there is pond as it the paper shows. My lord, finally, my lord, number of litigation, number of ground, protracted litigation. After that, my lord, the Kolkata Municipal Corporation recalled the sanction building plan. My lord, in one round in this court also, my lord, we enclosed all those documents. My lord, now we are praying, my lord, the order passed by the Kolkata Municipal Corporation be implemented. Now, the last occasion, my lord, some of the persons who received
This petition you have prayed for implementation of
the order which was passed under section 397 of the Kolkata Municipal Corporation. That is the demolition and restore back its in its own and original position so far the pond is concerned. And the last occasion when was the matter, my lord, cropped up, my lord, some person who were reside, my lord, they come and my lord, the request is honorable court to impede them as party since they are claiming to be the necessary party. Our humble submission at that point of time, even if they are party, they are given opportunity, because my lord, misrepresentation of facts are there.
of flats.
Of them. Misrepresentation and frauds are practiced, as it seems from the papers and document. But even my lord, the opportunity of hearing is given to them, nothing will change so far the order of 397 is concerned. Though my lord, ultimately, my lord, this honorable court directed us. Lords. আমাদের রিপ্লাই ফাইল করা আছে, রিপ্লাইটা ফাইল করে দিয়েছি আমরা। ছিল দেখলাম। কতজনের মধ্যে কতজন দেখো affidavit of
Now, whether the affidavits are complete as directed by this court. You are the added respondents.
You know, from my client that copy has been served upon our blood. I could not find the copy of the receipt.
You are representing all the added respondents.
I have tried to say that was allowed by so that is actually, when I see my reply, I have enclosed one document or order of this order. And this particular order was challenged before the
This order was challenged.
and that was rejected. But can you see my reply, page 10?
So this order date 9th of October 2022.
Challenged
By whom?
by my lord, the promoter developer who has my lord, against whom my lord, the whole proceedings was my lord, taken into consideration.
Show me the order of the honor.
My reply. My reply. Page 10. Not my
Page 10.
Page 10. Order dated my lord 10 January 2018. Page 32 is the included order before this one. In this report.
Oh, that was in the on the original side.
Okay. Swapna Chakraborty, the promoter. And that was my lord, appeal was also preferred. That was also rejected.
No, in that writ petition, the order of withdrawing the sanction plan was under challenge.
Yes, cancellation of sanction.
So this court refused to entertain the writ petition.
It was challenged before the division bench. That was also my lord. That is my lord page not to be fined.
Yes, yes, page 15 onwards.
Now my lord, they have challenged the same order. But now my lord, by filing their affidavit and all these things, we are only seeking implementation of the order.
That's
Which
true.
order as you find it.
You are appearing for the respondents have not been formally added in the writ petition.
We have soft copy, all of them, my lord, and it was direction upon the department. If I am not wrong.
Well, your lordship has directed us to supply the names and addresses.
Yes.
That we have done thereafter.
And we have effected service upon all. So, my lord, 3 envelopes have been written with some endorsement. My lord, the first person decided.
এটা নাবাওনি নাকি ডিপার্টমেন্টে? Now you should have also taken steps for correcting the cost title as leave was granted by this court. What you are doing? No, not only upon the department. Elaborate order was passed by this court. Yes. What steps you have taken? At least you could have assisted my officer also.
Maybe also my mistake, and I am petitioner.
No, it is their application for amendment for addition of party. Consciously done. To buy time before this court. After the aforesaid amendment is carried out, the learned advocate for the petitioner is directed to serve copy of the writ petition upon the added respondent. How you have done this without amendment? How you have done without amendment? From where you came to know? That the writ petition cost title of the writ petition was amended?
I am trying to concentrate on
Now there is a direction. You haven't gone through the order. On your application, Mr. Chakraborty, learned advocate representing the petitioner, has made a prayer for supply of particulars of all the flat owners, occupiers of the aforesaid premises in question by the learned advocate representing respondent number 9 to 13.
Supply.
9 to 13, so that those flat owners, occupiers can be made as additional respondents in this writ petition.
Supplied, we have effected service.
You are representing how many? Only 2. They are also the occupiers, flat owners. Rest of the flat owners, occupiers' names were supplied to you.
Supplied. And even, my lord, after on the basis of that, my lord, we have sent, my lord.
Mr. Chakraborty, do you have the copy of the order passed by this court?
No, my lord, now.
You haven't gone through the same?
My lord.
Learned advocate for the respondent number 9 to 13 is directed to share the details of the flat owners, occupiers of the said building within 10 days from date with the learned advocate for the petitioner. And on receipt of details of the flat owners, occupiers, learned advocate for the petitioners is granted leave to amend the cost title and add those flat owners, occupiers as respondents.
This is the first thing, my
You
lord.
have done this.
Yes, my lord. that mistake as it appears. My lord, the second thing, my lord, which is required to be done, directed to be done, you have done. But the amendment, my lord, this is a mistake, my lord, we have committed.
Application of Mr. Das was allowed,
Lord,
directing the department to amend the cost title
Lordship,
and add those two applicants as additional respondents.
Lordship.
In addition thereto, there is a direction upon the learned advocate representing respondent number 9 to 30 to share the details of other occupants
Yes, my lord.
/ flat owners to you.
Lordship.
And on receipt of these details, you are the learned advocate for the petitioner was directed to amend the cost title and add those occupants as additional respondents. You have not done this.
My lord, service, my lord, I have done, but
Department
this
has
is
also not done this.
Yes, my lord.
You have also not done.
The first thing, my lord, we have omitted. My lord, the second thing, my lord, this we have done, and my lord, mostly served.
Mentioned this
Yes.
matter before this.
Yes,
court.
Amended cost title and HO.
Yes, yes,
Two
yes,
stages order was passed.
yes, my lord.
Two occupants, flat owners came with the application for addition of party that was
Allowed.
directing the department to amend the cost title.
Lordship.
So for other flat owners, occupiers, Mr. Bhattacharya was directed to share the details. Details were shared, but you did not take steps.
As far as amendment of the cost title is concerned, my lord.
Unnecessarily, I have passed a long order. It has
It's a
not been
mistake, my
followed
lord.
by
2R is, no, 2R is human, my lord. Kindly condone this act of.
issue. Writ petition is taken up for consideration when it has been found that on an application being Can 1 of 2023, praying for addition of party, seeking addition of party, an order was passed on 9th October 2023, directing the department to amend the cost title of the writ petition and add the applicants in Can 1 of 2023 as additional respondents within a specified time. On perusing the cost title of the writ petition, next paragraph, on perusing the cost title of the writ petition, it transpires that amendment of cost title as directed by this court on 9th October 2023 has not been made, and applicants have not been made additional respondents. Stop. Department is directed to amend the cost title of the writ petition in terms of the directions as contained in the order dated 9th October 2023 within 7 days from date. Stop. The learned advocate representing the applicants is directed to cooperate with the department. Stop. You have served the copies of the writ petition upon the two applicants. Stop. Since it has already been submitted by Mr. Chakraborty, learned advocate representing the petitioner, that copies of the writ petition have already been served upon the applicants in Can 1 of 2023, comma, . the applicants within bracket to be added as additional respondents close bracket shall be at liberty. Have you filed affidavit in opposition? Shall be at liberty to file affidavit in opposition to this writ petition within 2 weeks from date, and affidavit in reply thereto, if any, be filed within 1 week thereafter. Stop. The next paragraph, the learned advocate for the petitioner was also directed now was also directed Corona was also granted leave to amend the cost title of the writ petition on receiving details of other flat owners / occupiers but Mr. Chakraborty has tendered apology that in spite of receipt of details of other flat owner / occupiers, they have not been added as additional respondents. Stop. The learned advocate for the petitioner shall be at liberty to amend the cost title of this writ petition in course of this day in order to array other flat owners / occupiers, details of whom have already been supplied by the learned advocate representing respondent numbers 9 to 13 in course of this day. Stop. Have you served notice upon them? Since notice has next paragraph, since notice has been served upon the other flat owners / occupiers after receiving the details from the learned advocate of the respondent numbers 9 to 13, these respondents, these flat owners / occupiers within to be added as additional respondents close bracket shall also be at liberty to file affidavit in opposition to this writ petition by 2 weeks from date, and affidavit in reply thereto, if any, be filed within 1 week thereafter.
That notice.
Stop.
Further notice dispensed with, my lord, since we have served them, my lord. Subject to my lordship. Pleasure.
Today they are not present.
Then again we will send.
Stop. Let this order be communicated to other flat owners / occupiers
Lordship.
by January 11th, 2020. And the learned advocate for the petitioner is directed to file affidavit of service on the agenda.
Lordship.
Next paragraph. List the matter under the same heading for further consideration on further consideration in the monthly combined list of February 2024. Let it be taken up, then you pray for time. Sorry, শুনবেন
তিনি বললেন monthly list.
এই যে অর্ডারটা দিলাম না, এটা আমি সই করার পরে ডিপার্টমেন্টে নামিয়ে দেব। পোস্টারের অ্যামেন্ডমেন্ট হবে আগের বারে অর্ডার দেওয়া সত্ত্বেও নামানো হয়নি পোস্টারের অ্যামেন্ডমেন্ট করেনি অ্যাডভোকেট বাবুরাও কোনো রকম স্পেস নেই এবারে যাতে সেম মিস্টেকটা না হয় আমি সই করলে এটাকে মার্ক করে রাখবেন সঙ্গে সঙ্গে দেখতে পাচ্ছি ইয়েস হোয়াট ইউ সাবমিট
Our appeal is pending before the building tribunal on 5th of February. That's why I was saying before my lord that the
why today if these formalities would have been if today these formalities were complete then I could have heard this matter since your appeal is pending I will sit I will wait
One more
till
aspect, my lord.
outcome of the appeal which is pending before the building tribunal.
One more aspect under section order passed under section 397 cannot be.
High Court will wait when the building tribunal will dispose of the appeal. You are safe today since no steps have been taken by Mr. Chakraborty.
What is here? That's why I have